I sent it to her. So I'll send hers to you.
Oh, yeah, there's more than this is.
Just have a moment to run to the restroom.
You do. I'm looking for a password. I'm trying to get the new and improved aggravated stalking pattern charge. And it's taking a minute. So you have a minute.
When I made the red rock and I gave it to you, there was a piece of paper taped to the front.
Okay, sorry for the delay. Ready, Ms. Rivers? Let's go back on the record in State versus Bryant, 22 SC 180-390. It is 9:45 on Thursday, the 29th, and we are going to start our charge conference. Before we do that, Mr. Whitenauer, anything from the state? Ms. Wood, anything from the defense?
No, yeah.
Okay, you should see on the screen in front of you the jury charge that I sent out last night. I think it was last night. The way I'm going to go through it is to jump to the areas where I have questions. If in getting to, let's say my first page is 6, I pass over something that you want to discuss, let me know, and we will cover your questions or concerns first, and then get to whatever segment mine was. And if I again skip over something where there's question or concern, just let me know. So if I get back in the document, and I should let you all know, it's all pattern. I sometimes edit it a bit to make it more accessible. So if you have had grained into you the literal pattern and it looks a little different, don't panic. We can talk about whether there has been some degradation in meaning. But what I try to do is make these charges as accessible as possible to the jurors. So my first question is with credibility of witnesses. I don't know that we've had any impeachment or I guess bolstering by presenting someone with her or his out of court statements. So I don't think we need to give that highlighted language, but we have at least one more witness left. So we can leave it in as conditional if that comes to pass, but it doesn't seem like this is a case where people's suppression hearing transcript is being used to impeach them or bolster them. Mr. Whitenauer?
I would agree, Judge.
Ms. Wood?
One moment, Judge. So we're talking about the highlight section.
Yes, ma'am. I'm only asking about, I stop where there's highlighted stuff.
Understood.
I think the only thing that touches on that is her, the body cam, like kind of her description of what happened when she was telling the police versus her testimony. But I don't have a strong opinion as long as the court's giving the rest of the charge.
Okay, I don't mind giving it. And when you say she, you're referring to Ms. Thomas as opposed to Ms. Bryant. Okay, I mean, if it's something that you're going to be highlighting in a closing, that hey, we hear this in court, but we saw that on the body cam, then this makes sense. It's good law. I just don't. So is the charge on proximate cause for civil cases. I'm not going to put that in here, but I'll leave it in. It sounds like we're going to hear yet more body cam, and so there may be other instances of that. Okay. Defendant's choice not to testify is in for now, but I will take that out should Mr. Bryant decide to testify. Then that won't be something that we'll talk about. Then we get to the raft of charges about the statement of a defendant. And I know we haven't heard the body cam from Sergeant Broussard, But these don't seem quite to fit unless what we're going to hear from Broussard is that he Mirandized Mr. Bryant. If he didn't, then these are going to be confusing and misleading because there was no Mirandized statement given. So I'm going to start with you, Mr. Whitenauer. I know out of an abundance of caution, you asked for these, but now they're in and they ought to be removed if we don't have a Mirandized statement. But they shouldn't be removed if the defense perspective is he should have been Mirandized and he wasn't. And so this is a zinger. But if he wasn't Mirandized, I don't understand why it's not coming in, why it's coming in, and why there hasn't been a motion to suppress. So I guess I'll need to hear from both sides. But I'll start with you, Mr. Whitenauer.
Judge, I don't anticipate body cam that we would intend to tender through Sergeant Broussard would show any statements that would require these instructions to be given to the jury. So I think they can be removed.
Okay, Ms. Wood.
I agree, Judge. I believe this is not an issue for us.
Okay. Then we get to prior difficulties and prior convictions. I know, Ms. Feely, you were asking about that in the email that went out last night. On the screen now is what I intend to share with the jury, consistent with the limiting instruction I gave at the beginning of the trial and in the midst of Ms. Thomas's testimony. So I don't think, first of all, prior convictions doesn't fit because I don't think, unless Broussard has prior convictions, that's coming in, or Ms. Wood misled the jury because she has told them that Mr. Bryant doesn't have any convictions. So I don't see there being prior convictions. Prior difficulties, yes, they heard about them, and that evidence needs to be considered in a limited way. And I think this charge does it, but I'd like the defense input.
I think this is fine, Judge.
Okay. Mr. Whitenauer, any concern?
Yes, Judge. So he does have prior misdemeanor convictions, and depending on what he testifies, those could be addressed.
Okay, so what was said in opening is that well, I don't know what was said. If it was no convictions, the jurors will be surprised. If it was no felony convictions, that will be reaffirmed. And it may be that nothing comes in, but it does depend, should Mr. Bryant testify, how he presents himself. What are the misdemeanor convictions for?
One is for battery in 2009, and the other is for theft by receiving stolen property in 1999.
Okay. Is Ms. Thomas the victim in the battery case?
I don't know, Judge. I'm getting that certified right now.
Oh, okay. So I will leave this one as a conditional, sort of like defendant testifying or not testifying, but that's the only scenario in which you see convictions coming in.
Yes.
If Mr. Bryant testifies.
Yes.
Okay. So what we ought to do then is, if Mr. Bryant testifies, after his direct is done, we may need to take a break just to have a discussion amongst the lawyers, Mr. Bryant and myself, about whether the state believes it then is appropriate to introduce the fact of those convictions and maybe the convictions themselves based on what Mr. Bryant said in his direct exam. So help me remember that.
Yes, sir.
Okay. Identification. It is a true statement that the state has to prove the identity of the person who committed the crimes beyond a reasonable doubt. Beyond that one sentence, I don't think we need any of the other language. In fact, I don't think we need identification at all, because that's not the nature of the defense. The defense is there was no crime. Mr. Bryant was exactly where he was supposed to be based on the TPO he had, whatever. It will be articulated more clearly than that. But I didn't want to exclude identification altogether if the defense wants that first sentence in.
I agree, Judge. You're correct.
So take it all out or just have that one sentence?
I'm fine with it all being taken out, Judge.
Okay. Any objection to that, Mr. Whitenauer? Okay. So I will not charge on identification. think that makes sense. The jurors will spend no time on identification. Aggravated stalking. I'm going to give you a minute to read it, what you have on the screen now, and I have to scroll down a little bit. You know what I'll do? I'll make it easier. I'm going to print out pages 9 and 10. So you can start reading it. It's the same language. It's organized in a way that our pattern jury instruction committee for Superior Courts has decided is easier for jurors. I say it's the same language. It's better language, but same content. And I'll get you a hard copy in a second. Mike keeps jumping. There we go. Mr. Whitenair, do you mind grabbing one copy for you and one for the defense?
Yes, sir.
Thank you.
So the part that comes after those double lines, that's all getting deleted.
Right, that's the old language, but I left it in there so folks can compare and contrast. The new language is what we've got. How's it looking in the jury room? 12.
Yes.
All right. Is Mr. Grayson, his name, our last Royster? He's not here. Come on. All right, Mr. Whitenair, have you had a chance to review the new and improved aggravated stalking pattern charge? Any issues with that? Ms. Wood?
We reviewed it, no issues, Judge.
Okay, I'm going to modify it in the way that you see on the screen. I don't think there's any evidence that there was telephonic or computer network based contact in this case. It is communication in person.
Thank you, Judge.
All right. Someone asked for lesser offense. Not sure what was included, what someone was thinking, but I didn't think it fit, so I'm looking for guidance. State, was that your request?
No.
Okay. Ms. Wood?
We would withdraw that request.
Okay. those were the questions or issues that I had. Mr. Whitenauer, was there anything else in the charge that you had a chance to review that you wanted to discuss now?
No, Judge.
Ms. Wood? Ms. Feely?
Sorry, I made this request before. I just want to again reiterate that we prefer the pattern on the single witness charge. Which includes the language of that the testimony of a single witness if believed is sufficient to establish a fact.
Okay, bottom of page 3. Got it. So you're objecting to my exclusion of the clause if believed. Understood. All right, I'm going to leave it as is, but your objection is noted. Anything else, Ms. Feely?
No.
All right, I will clean this up, remove the stuff that's out. A couple things will need to stay in there tentatively as we see how the rest of the trial unfolds. Once that becomes clear, then I'll get a final version, hard copy to everyone, and we'll go from there. What do we have now?
He's waiting on the shuttle.
He's waiting on the shuttle, Mr. Royster. Okay. Everyone else is here. We got 13. Okay, great. Do we have Sergeant Broussard?
Yes, Judge.
Bet he's
Here
been-
at 9:30.
I bet, okay. He's standing like this. All right, you all can be at ease until we get juror number 14. It's National Coffee Day. I don't know if you people are coffee people. I'm not, but if you are, it's apparently a good day for you.
To drink tea.
Milk.
I'll work you up to the top and two. No milk. Can I step out?
Please.
How long?
Well, I wouldn't go far.
How long we are?
Yeah, moment number 14 gets here, well, the last juror gets here, we're gonna get rolling.
I think I brought it.
So.
I'm gonna go print it from honest and then, the reason why, I'm supposed to go thankful for something.
I like that color.
You think he's here?
I'm checking right now.
Oh. How would he sneak by you? How would he?
The door's closed now.
Oh. Can we arrest him? I heard them ask, do you have his phone number? I'm glad he has to go there first. They're gonna, you may need to intervene.
Before he got caught yesterday, he was like, won't be on time.
Exactly. He's like, oh, I'll be early. And they were like, you'll be here 9:30. Not so much. We should have had Broussard pick him up. That's the one guy.
I think it'll be a party.
I think he just showed up.
He's here, Judge.
All right. Did he get at least like one prong of the taser? Well, we're going to get rolling, Ms. Green. You're going to be handling Sergeant Broussard?
No, Judge.
Okay.
We're gonna get IDA Whitenhour
All right.
in here right now.
Is Wood anything we need to cover before our jurors come on in?
No, Your Honor.
Okay. Oh, what's the latest? I should have engaged with Mr. Bryant on this as well. After Broussard state rests, Mr. Bryant, you will at that juncture need to be deciding whether you're going to testify. You and I will have a conversation on the record outside the presence of the jury about your absolute right, regardless of what your lawyers say, to take that stand if that's what you think is smart. And your equally absolute right to not take the stand and have me tell the jurors that they are to draw no inference or conclusion, hurtful or harmful or anything from the fact that you did not testify. So once the state rests, jurors are going to step out and you and I, with your lawyers here, will have that conversation. You may have already made up your mind. Don't tell me now, but do know that the response to my question should not be, I'm not sure yet, I need more time. It'll be, yes, I am. No, I'm not. If Mr. Bryant does not choose to testify, do you have other witnesses at this time you would expect to call?
No, Your Honor.
Okay. All right. Good. Then let's bring the jurors in, please.
I mean, this. Just need this.
All right, it's yours. I'll do the prayer.
Thank you, Deputy Gordon. You all can be seated. Mr. Royster, you're gunning for a spot on the wall of shame. Jurors who just can't figure out how to get here on time. If we spill into tomorrow, everyone else is going to have a reporting time of 9. You're going to have a reporting time of 8:30. Okay? All right. Ladies and gentlemen, we remain, first of all, good morning. Thank you for being here. Most of you, almost all of you on time. We are going to continue with the state's presentation. The state had started to call Sergeant Broussard. We looked at the time and we had to stop that because his testimony and overall presentation was going to take more than 15 minutes. So when you're ready, Mr. White, now you can officially call your next witness.
State is ready and officially calls Sergeant Broussard.
Excellent.
Testimony you will give is the truth, the whole truth, and nothing but the truth forever.
I do.
Go ahead and have a seat. Just go ahead and have the record.
Sergeant, I'm sorry to interrupt you before you even started. Bad manners on my part. But my request, if you're comfortable with it, is that you remove your mask so that everyone can hear you more clearly.
Sure.
Thank you so much.
Yes, sir. Sergeant Nicholas, Nicholas, last name Broussard, spelled Broussard, East Point Police Department.
Good morning.
Good morning.
All right, go ahead and make yourself comfortable. Scoot up to the mic. Don't fall off the ledge there. That happens sometimes. First question, what time did you get here this morning?
I got here, believe it or not, at 9:08 a.m.
All right.
All right. Should have had you pick up Mr. Royster.
All right. So you said you're with the East Point Police Department. Is that correct?
That's correct.
And how long have you been employed with the East Point Police Department?
For 18 years.
Were you in law enforcement before that?
Yes.
And where were you employed before that?
Was employed with the Hayfield Police Department for 2.5 years.
All right. And you're currently a sergeant, is that right?
Yes.
What are your roles? What is your role and responsibilities as a sergeant with East Point Police Department?
Responsibilities as a uniformed sergeant is one, to make sure that all of the cars are actually operating prior to service, collecting paperwork as far as lineups are concerned for the watch commanders, communications, and the jail. I'm also responsible for hosting roll call. I'm the lead sergeant or the senior sergeant that's responsible for the day watch unit right now in Field Operations Division. We'll go through any daily bulletins that may come out as far as extra checks are concerned, any bolos that may come out as far as any serious cases that came out, anything that was previous with any previous watches such as morning watch or evening watch, discuss any repeat calls that we may have had, just a debrief. And then from there, I give each individual officer their beat assignments and which car they're actually going to be operating. From there, I just ask everybody if there's nothing that anybody has, any questions, comments, or concerns on what was discussed. Then from there, I'll call the watch. which means that the watch that's on right now or the watch that was on previously was morning watch. They understand that their tour of duty has officially ended. Ours officially begins. Communications at that point will notify me that if there's any calls that are pending for service, such as alarm calls, any burglary calls, any fight calls, any domestic calls, anything that's holding or any wanted people that need to be picked up. And that's when I take paperwork to them and I take paperwork to the jail to see if there's any people that were arrested that need to be transported over to the Fulton County Jail, where they can actually receive due process before a judicial officer on charges that we are accusing them of. And from there, I'm also responsible for monitoring every and all call throughout the city and responding to all calls such as priority ones and priority two calls. Priority one means the most important, priority two means the second most important type calls.
All right, thank you, Sergeant. And how long have you been a sergeant?
Been a sergeant for 3 years now.
All right, and before that, what was your title?
Well, actually, my apologies, 4 years now. Before then, I was actually assigned to the Criminal Investigations Division, where I was a detective with the Evening Watch at that time. I was responsible for major felony cases, all missing person cases, any property crimes that actually occurred, any follow-ups. If I was assigned anything from an alarm call, anything involving a property crime up to a missing person or a major felony, such as a homicide or any domestics that may come out in a particular zone. Before then, I was actually assigned to special operations, where I was a narcotics investigator and a canine handler. As a matter of fact, I'm currently working on my second dog right now. So I did special operations for 8.5 years, where I was responsible for comprehensive traffic enforcement on the local highways of East Point, as well as the state routes and the interstate routes as well. Any mutual aid calls that any municipality, county, or state agency had, or even the federal agencies actually had if they needed a dog, which was a single purpose dog for narcotics detection. I was also responsible for helping investigations as far as dealing with informants if we had any drug complaints that came out, where if we need to make control buys, if we need to serve warrants, if we need to help CID, which is the Criminal Investigations Divisions on any warrants, I was responsible for it. So anything on mutual aid that needed some degree of attention, basically special operations was responsible for it.
All right, Sergeant, let me ask you,
Sure.
in your 20 years of experience, and that's a long time in service.
Thank
Would you
you.
agree?
Yes, sir.
And thank you. Can you briefly tell the jury a little bit about your education and your training? You've already given some testimony about your experience. What education and training briefly have you received in your career?
Sure. I started in January of 2002 at the Fulton County Public Safety Center, where we learned basic mandate, basic law enforcement, as far as the fundamentals of policing. That covered everything from juvenile crime, domestic violence cases, burglary calls, being a first responder. What do we do when we respond on the scene as a first responder? Making sure that any and all evidence that needs to be collected, we do so accordingly. Make sure that any type of preservation of evidence needs to be preserved and what needs to be done, what steps needs to be done. In addition to that, we made sure that we network with the courts and what the courts expected us to do as far as the current case law. Case law changes all the time. From there, I actually received education from the Drug Enforcement Administration, where I did comprehensive investigation there on narcotics investigations. I've also done basic fundamental criminal investigations over at the Georgia Public Safety Training Center, where it covered everything from the origin of where policing started all the way up to fundamentals in criminal investigations. It also touched on family violence, on what needs to be done, what our responsibilities are on a response time, and how to identify a primary aggressor and a victim. If we are not able to identify a primary aggressor or a victim where there's any degree of injuries or any degree of property damage, what type of decisions we need to make once the totality of circumstances have all come to fruition to us upon conclusion of the call, and what kind of key decisions that we actually need to make on any and all calls. But of course, everything is not the same. It's always on a case-by-case basis.
All right, Sergeant, and let me ask you, are you currently post certified?
Yes, I am.
And can you tell the jury what post means?
POST is a 4-letter acronym. Basically stands for Peace Officer Standard Training. We're basically mandated to get a minimum of 20 hours per year to make sure that our certification is in great standing. Also, there's accountability there where, just like you guys, we have to make sure that we do our very best not to get arrested. If we do, we have to be able to report this to the council that we've been arrested, or if we're accused of any crime whatsoever, if there's any investigations that's going on against us, we have to be able to notify them if anything takes place. So ethics is basically really huge on accountability in that aspect. But at the same time, even though it's a minimum of 20 hours, I do my very best to get at least 100 hours a year. So there's certain things that we do, like on de-escalation, family violence, on in-service, that we discuss when we requalify twice a year. We always discuss this in-house when we do it within the police department and the training instructors there. We make sure that we either give scenarios, discuss certain cases that may have come up on family violence and how it applies, the way Georgia defines family violence, and what steps are we taking, and if there were any mistakes that we made, what corrections are we doing to clean it up, so that way mistakes never happen again, where a victim is given due diligence on our attentions, and we basically satisfy the courts and the district attorney's office on our responsibility and what we did from the very first initial response to the scene all the way up to the detective that gets assigned to the case. In the event there's a court proceeding that actually takes place, whether it's a civil case or a criminal case that takes place all the way to the end.
All right. And were you post-certified on April 30th, 2021?
Yes, I was.
All right. And you recall being dispatched to 3286 Sir Henry Street in East Point.
Yes, I do.
Is that address in Fulton County?
Yes, it is.
All right. And what information did you receive before arriving?
The operator dispatched, where's policy that we have? The operator dispatched the primary unit, a backup unit, and supervision. It falls within priority 1. Since it was a fight call, also it was a domestic related fight call. In addition to that, the operator stated that both parties were actually on scene, so I responded to the scene. So one advantage that I actually have is, with good graces with the chief, is we actually have the ability to view inside of the car, in the cabin of the car, on a Panasonic Tough Book, which is also known as a mobile data terminal. It will outline the caller, the name of the caller, telephone number for the caller, the address where the call is actually coming from, and then there are notes exactly, what's going on, just like a synopsis.
All right. So when you arrived on scene, you had a fair idea of what was going on there.
Yes, I did.
All right. And when you arrived, what did you observe?
Once I arrived, the initial officer was actually on the scene already. So I walked over to the scene. I parked probably about 20, maybe 25 yards away from the house. That's just a safety practice that I always learn. That's a practice that I always teach to the troops that I supervise. Because besides us being armed on the scene, you never know who's armed. So I go to the scene, and once I go to the scene, there's multiple adults out there, multiple females there, and one adult male there. And the initial officer was actually engaged in a conversation with the two parties that were actually on the scene. He was engaged with the caller, and he was also engaged with the person that was actually being accused of the fight on scene. So my responsibility was just to sit back and observe the entire scene. And once I was observing the entire scene, I don't interact unless it becomes a safety issue or if the officer on scene has a question.
And were you eventually able to identify the person who had been suspected of the fight?
Yes, I was.
And do you recall that person's name?
Yes, I do.
What was that name?
The name of the accused was Stewart, S-T-U-A-R-T, Bryant, last name spelled B-R-Y-A-N-T. And the accused was actually looking right at me, and he even pointed me out and said, "I remember you from the last call."
And did you remember him?
Yes, I did.
All right. And we'll talk about that in a moment. And were you able to identify the female adult that was on scene, the 911 caller?
Yes, I was.
Who was that?
That was Malika, M-A-L-I-K-A, last name Thomas, T-H-O-M-A-S. She was a female that was standing to the right of the officer who had paperwork in her hand, and she was giving a active description of what was going on once I walked up.
Did you eventually learn of there being a minor victim on scene as well?
Yes, I did.
And were you able to learn that person's name?
Yes, I was.
What was that person's name?
Her name was Elizabeth, Elizabeth. Last name Bryant, Bryant. And that victim, juvenile victim, was standing to the left of the officer.
How would you describe Mr. Stuart Bryant's demeanor?
Mr. Bryant was aggravated. He was upset. I mean, he was controlling. When the officer was having conversations with the caller, he was controlling, interrupting him during the course of the time where he indicated that he had paperwork and says that this is my house. And it was to the point where Mr. Bryant was so disruptive, where the officer instructed him not once but twice that he needed to walk away from the scene, pointing in the direction of the yard, which was further away where he can understand what our caller was telling him, so he can basically evaluate everything, what was going on at that time to come up with a conclusion.
And what was Ms. Thomas's demeanor like?
Ms. Thomas was visibly upset. She was scared. Hands were shaking. And you can tell that she was agitated because she was actively hosting a birthday party for her son. And she indicated that her son had friends there. We also saw a pickup truck that had a large trailer, where she indicated that she had a gaming system that was on the scene. And she also had friends of, or his peers that was actually on the scene. And the biggest thing that she was trying to do was to keep them away from the argument that was taking place. Ms. Thomas was indicating that, profanity was being used, where Mr. Bryant was extremely upset, where there was a water cooler that was actually.
Your Honor, this is all you're saying.
Your Honor, that witness has testified and was available for cross-examination, so I don't think this is objectionable.
Cumulative and bolstering them.
Okay. I mean, it's still hearsay if this witness is talking about what someone else said, if you're offering it for the truth of the matter asserted, as opposed to some other reason.
I'll move on, Judge.
Okay.
All right. And do you recall what Elizabeth Bryant's demeanor was like?
Elizabeth Bryant?
Elizabeth Bryant, the minor.
Okay. She was visibly upset. Her hands were shaking. Ms. Bryant also indicated that she broke a nail and she also had scratches on her arms. So
Your Honor, we would object to your saying.
Okay. I understood, and I'll sustain it insofar as it is verbal recitation, but the testimony to me was a little unclear as to whether these were things that the sergeant could observe, and he's certainly free to talk about what he observed, as opposed to Ms. Bryant said, "Look at these scratches on my arm." So if you want to dial in that way, Mr. Whitenair, you're free to do so.
Thank you, Judge. So you've described Ms. Bryant's demeanor, yes?
yes, I did.
Did you make any observations of her?
I did.
And what observations were you able to make of her?
Both of her hands were shaking uncontrollably.
Were you able to observe any injuries about her?
Yes, I was.
What were those injuries?
Scratches along her hands and her wrist.
While you were on scene, did you have an opportunity to view the physical relation of Mr. Bryant, Ms. Thomas, and Elizabeth Bryant out in the front lawn?
Yes, I did.
And were you able to estimate how close Mr. Bryant was to Mrs. Thomas and Miss Bryant?
Yes, I was.
And about how close was he to them?
Approximately 3 to 5 feet.
Is 3 to 5 feet less than 200 yards?
Yes.
All right. What is a TPO?
It's a three letters that stands for a temporary protective order.
Okay. And in a case like this, what steps do you take to determine whether a TPO has been or is being violated?
There's two things. One is I'll ask the caller if it's brought to our attention that a temporary protective order exists. It's my responsibility to confirm that if they have proof of it. If there's any paperwork that was actually with a Fulton County letterhead that was signed off by a Superior Court judge, there's any documentation that they can present so I can review it. Nowadays, even at that time, you can also get it electronically. If it's done electronically, I'll take a look at it or have that person send me an email where I have the ability, since I have a working Panasonic Toughbook that's in the car with internet access. If they can email me on the scene, if I'm clearly believing that the scene is safe, and I'll review it myself. In this particular case, if there's paperwork that's actually present where I can review it, physical paperwork, I'll go through it line by line. Once I go through it by line, I'll determine who is the petitioner and who is the respondent, starting from the top, from left to right. From there, I'll look at the address where it's actually listed. And then, I'll just confirm the address on the house, which I always do. And then from there, I'll look at each line on, what was asked or what was described, or it's kind of like a checklist, like where a petitioner will actually initial off on each line by line, and there's multiple pages. So once you flip through it, you'll see if there's actually a signature done by a judge. If it's a signature that's actually done by a judge, then in this particular case, it's the responsibility and the burden of proof is on us to confirm that if there is a respondent present on the scene or not on scene, that the respondent has been served. So from there, there's two ways that we can do it. One is you can either give a telephone call to the Fulton County Sheriff's Office Civil Division, which is very hard because they're never available to answer the phone. Or two, which thank God for the Georgia Crime Information Center, they make it efficient for us. You have the ability to either check on the computer that's inside the car, or if you don't, you can actually radio it into an operator when you're checking that person for wants and warrants. And then if you want to stipulate it a little bit further, you can ask the operator if there's any protection orders that's actually listed within the Georgia Crime Information Center. And the operator has the ability to tell you yes. And they also have the ability to tell you if it's active. Same thing if you actually go inside of the cabin of a patrol car, you have the ability to view it within the patrol car as GCIC, or I'm sorry, the Georgia Crime Information Center would actually distribute it out, where you can read it from top to bottom, left to right, and see if it's active or not. Or if, in this case, if it's not active, you won't see anything at all that indicates where a person has actually been served.
All right. And now, in this case, were you able to speak with someone who had a copy of the TPO or protective order?
Yes, I was.
Who was that?
That was our initial caller, Miss Malika Thomas.
All right. Your Honor, may I approach?
You may.
All right. Sergeant, I'm approaching now with State's Exhibit 7. Yeah. All right. Please review that document and let me know if you recognize it.
I recognize it.
All right. And is that the same TPO that you were provided that day, April 30th, 2021 by Ms. Harris?
Yes.
All right. Now, in reviewing that TPO, was there any part of it that stood out to you in terms of notice to the respondent, the defendant in this case?
That's correct. As far as the stay away is concerned.
No, and I'll direct your attention to the first page.
Okay.
And the first paragraph there.
Okay.
And did anything about that stand out to you in terms of notice to the respondent?
That's correct. It basically indicates that a hearing took place. Took place on the matter. I'm sorry.
Discussing a document that's not been entered, and also what was just said was hearsay about a hearing being conducted.
Okay, couple things. Exhibit 7 was admitted through Ms. Thomas, is part of the record. So that's something that could be published, read from. Its contents are in the record. So secondly, I don't think we're in the hearsay space insofar as Sergeant Broussard is sharing with the jury the contents of something that is in the record. Okay.
All right. So Sergeant, again, directing your attention to the front of that document, the first sentence there, would you read that to the jury? And did you read that on April 30th, 2021?
I did. A hearing was held on this matter of July 22nd, 2021, for which the respondent had notice as required by law, at which the respondent appeared and or had the opportunity to be heard, and the petitioner requested that the protective order entered in this case be continued.
Okay. And for you, was that significant in terms of determining whether the respondent knew about this TPO?
Yes,
All right. Now, did the date that you reported to 3286 Sir Henry Street, that being April 30, 2021, did that fall within the dates in that TPO? I direct your attention to the first page of the document.
this one is, the dates are different on what I read. I'm sorry, on what I reviewed on the day of. This is on the first page, it has from July 22nd, 2021 until July 21st, 2024.
Oh, I'm sorry, I'll provide you with the, I apologize, let me get you this is the three year, let me get you states 6, my apologies. All right, I'm showing you now states exhibit 6. So let's start again. Was there notice on that order?
And before we go, 6 is also in evidence, so you're welcome to preserve any objections you want. I'm gonna have the same ruling to them because 6 has also been admitted. It's a court record.
Okay, my apologies for the mix up between the two exhibits. Is this the TPO state 6 that you reviewed on April 30th, 2021?
This is, yes.
Okay, and is that what notice statement is provided at the top of that TPO?
The hearing was held on this matter on June 19th, 2020, for which the respondent had notice as required by law, at which the respondent appeared and or had the opportunity to be heard, and the petitioner requested that the protective order entered in this case be continued.
Okay, and what are the dates that prohibit contact or that order is in effect in that order?
June 19th, 2020 until June 18th, 2021.
All right, and so back to my last question then, did the date you reported to the 3286 Sir Henry Street address, April 30th, 2021, fall within the dates in that TPO that you reviewed when you arrived on scene?
Yes, it did.
All right, and that day, did you have access to GCIC that was through your computer in your patrol car?
Yes, I did.
All right, and was that computer, that terminal, lawfully connected to GCIC?
Yes, it was.
And you've already talked a little bit about what information can be retrieved through GCIC regarding a TPO. Did you attempt to determine whether this TPO had been served on the respondent, Mr. Bryant?
Yes, I did.
Okay, and were you able to make that determination?
Yes, I was.
All right, and what did you learn?
Once I was able to match the dates according to the order, and I was able to confirm it on the Panasonic Tough Book itself, I saw the dates, and then I got out and I reviewed it again outside of the patrol car before I made the conclusion that we need to take action in terms of an arrest. So I went through it again on the first page as I read, and then I went through it again to confirm on what was asked of me earlier as far as the proximity on what I saw, and also how many yards he was supposed to stay away. So that's once I made that determination, when I saw it again, that it was actually signed off and initialed, that's when I made the determination to instruct the responding officer to arrest the accused that was on the scene.
Okay, but in response to my question, were you able to determine whether the respondent had been served on this TPO?
Yes.
Had he?
Yes.
All right, and were you able to determine whether that TPO was active on April 30th, 2021?
Yes, I was.
And was it?
Yes, it was.
All right. Based on those determinations, what action did you take?
So again, I walked over with the paperwork and I handed the copy back to the caller, Ms. Thomas. And that's when I instructed the officer to arrest the accused that was on the scene.
Okay, and what was the defendant arrested for?
He was arrested for 1 count of aggravated stalking and then also 1 count of simple battery.
All right, and Your Honor, if I could just pause for a moment. I'm gonna move this last screen. We're getting some interaction between the witness's chair and the screen.
Thank you. I noticed that too. I guess the screen got moved a little bit in the evening. I don't want the witnesses to be unable to turn or to break the monitor.
Okay.
Sergeant.
Yes, sir.
All right, were you present while the defendant, Mr. Bryant, was being placed under arrest?
Yes, I was.
All right, and while he was being arrested, did the defendant make any spontaneous statements indicating knowledge of that 12-month TPO?
Yes, he did.
What did he say?
He indicated to myself and the responding officers, the order expired.
Okay. Now, do you wear a body camera while you go out on calls?
Yes, I do.
All right, and were you wearing your body camera on that day, April 30th, 2021?
Yes, I was.
All right, and have you had an opportunity to review the video from that body camera from that day?
Yes, I did.
Your Honor, may I approach?
You may.
What are we up to?
No.
Showing now State's Exhibit 9 to defense. And Sergeant, I'd like to show you those marked State's Exhibit 9. Do you recognize that?
Yes, I do.
How do you recognize it?
It has my initials at the very top, NMB for Nicholas Markel Broussard. It also has my employee number, which is 4984. It has my date on it, which is 9/28/2022. And it also has written by the communication supervisor or whoever wrote on it, Broussard arriving on scene, clerk TPO, make arrest, signal 58, Stuart Bryant. And there's also the court's case number, which is 22 SC 180390.
All right.
What's a signal 58?
It's a domestic.
And did you have an opportunity to review the video on that disc?
Yes, I did.
And was that video from your stop at 3286 on April 30th, 2021?
Yes, it was.
Was that video a fair and accurate representation of what was recorded that day?
Yes, it was.
Were any alterations, deletions made to that video?
No, there wasn't.
All right, Your Honor, at this time, State, we move to amend State's Exhibit 9 into evidence
Any objection?
No, Your Honor.
Exhibit 9 is admitted.
and permission to publish.
Granted.
No objection from the defense. I'll move past our driving here.
That's fine.
Go for it. What's the jingly noise?
Handcuffs.
All right, I'm going to pause for a moment. Are you able to see that on your screen?
Oh, yeah, you may have it.
I guess it's live streaming.
Stay muted. So press the button that says stay muted. And then the button that says got it.
Now you're good to go. Thank you.
Yes, sir.
So are you able to see the frame that we paused on?
Yes.
Who do you see in that frame?
I see the defendant that's standing to the left wearing all black with a beard and glasses, black shoes. I also see the juvenile victim that's standing to the left of the officer with her hand behind her back. Looks like she's holding a cell phone, blue jeans, and she's wearing a black shirt, maybe brown top, and she's also wearing either black shoes or black slippers. The officer that is on the scene is Officer Clairvaux, Clerveaux. He's the responding officer that responded to the scene. And to the right, I can't make out the face as of yet. It looks like it's a female wearing green.
All right, and by your estimation, is Mr. Bryant within 200 yards of Miss Bryant?
Yes.
Yeah, I got scared going as well. I saw you the last time I was out here.
Are you able to identify Ms. Thomas now?
Yes, I am.
All right. And what is she wearing there?
Miss Thomas is actually wearing all black. She's wearing a black hat with white letters. You can see the letter R as in Robert on her left, our right. She's also standing to the left of the accused. Also, she's standing to the left of the officer, which is Officer Clairvaux. She's standing straight ahead in front of the juvenile victim that's actually looking at me. And there's also, like I said, another female, unknown female that's wearing all green, well, a green shirt, and her hair is in a bun, and the top part is in a bun, and the rest of it's combed down, I guess, to the small of her back.
All right. And Sergeant, by your estimation, is Mr. Bryant within 200 yards of Ms. Thomas in this screen?
Yes, he is.
I had these copies made for the same.
Hey, come on, man. Over there. Over there.
Here.
Over there, bro.
And were you able to see the officer making instructions to the defendant to leave twice?
Yes, sir, I was.
Is that what you were referring to earlier?
Yes, sir.
I'm having a birthday party for his son. My son, he's here, and he comes in, jumps out the ice pool, saying it's his. I got to get out of his house, and I have these documents. I don't have to believe it. His back here, my little bro. That's his child. Coming in cursing us, calling us bitches, telling us to get the fuck out. I got a backyard full of shit.
Court order still.
It's my brother's birthday party.
June 2021.
What is that document?
That's going to be the temporary protective order that the caller gave to Officer Clairvaux. And that's when Officer Clairvaux handed it to me, and it's the document that I was reviewing, which is the same document that's in front of me right now.
That states Exhibit 6?
Yes, it is.
I remember because he came over here last time to get property.
What do you mean by that statement?
We actually, I was familiar with this call. What I mean by that is the accused actually was the person that called. I believe it was a few weeks before this one, because it was rather a recent call. And the accused indicated that he needed to get property. He just needed to have a police escort to go with him to get property. And he didn't want any trouble. He didn't want to have any retribution on him whatsoever while he retrieved property. He just wanted to pick up his belongings and then leave the scene. He just needed someone to stand by while he did it peacefully. So myself and I don't know which officers were on the scene, but there was 2 additional officers that were on the scene. We stood by while he went downstairs in the living room area and upstairs to retrieve property. And then once the accused was actually satisfied with property, that's when we all left together. The accused actually left the scene first, and then we left immediately afterwards.
You know why he was there to retrieve his property?
The only thing that he indicated was that he had a court order. He just wanted to get property. He wouldn't specify or elaborate exactly what the court order entailed. He just wanted to get property so that way there wouldn't be any type of trouble. And we agreed, and we said, okay, no problem. We'll stand by just to make sure that everything is okay.
Remember, I was doing it. He's taunting my mom. You just heard that shit from me on her nose, and I smacked. Okay. And this is my son's birthday. Got the gaming truck outside for my boy. A water slide in the backyard full of kids.
727, 10-4.
He doesn't even have a license. I don't know how he got over here. Right.
This
take him away.
Because he had to come here.
727, confirm you're at Marketplace Boulevard in North
Stuart Bryant. What's his birthday?
October 76.
October 31, 76. Let me check and see if it's on TCIC. If it is, then we'll go from there. State it with them.
What did you just indicate to the parties there?
So I'm asking the caller, Ms. Thomas, what's his date of birth? And that's when she gives me October of 1976. I didn't remember the date and I couldn't make out the date. And I said, okay, I'm reading based off of what I have here that, of course, her being the caller, she's the petitioner. Once we identified Ms. Thomas, and then also Mr. Bryant is the respondent. So as I'm reviewing the documents, as you guys saw, I'm walking back to the patrol car to be able to verify this. And the reason why I'm verifying this, and instead of over the radio, you guys heard there's a lot of radio traffic that's taking place. We're on evening watch, which is from 4 p.m. to midnight. It's the busiest watch where we average anywhere from 100 to 150 calls a night. So just to the importance of the channel to keep it clear in the event it goes bad for anybody. That's when I'm walking back to the patrol car so that way I can utilize the Panasonic Toughbook where I have internet access and also access to the Georgia Crime Information Center. One, to check for wants and warrants on the accused, and also to check to see if there's confirmation with this protection order that it's actually on the Georgia Crime Information Center and to confirm that it is valid.
And so from here is, you're walking back to your patrol car, is that right?
Yes, I am.
If there's no objection from defense, I'll avoid the jingling as we return.
No objection.
All right, and here in this frame, you return to your patrol car, is that correct?
That's correct.
And are you about to do what you just described?
That's correct.
And what are you doing here as we fast forward to 5:39?
Once I was able to confirm on the Panasonic Toughbook that you can see where my hand is right above it behind the windshield, that it is a valid warrant. I'm looking at it again because I was skimming through.
Valid warrant?
I'm sorry, not the warrant, the protective order itself. My apologies. And I'm specifically looking at the distance as far as the no contact order, which was 200 yards. And then also to confirm what I initially saw as far as not having any contact whatsoever. So once I was satisfied with it, looking at it right here, since I have distance away from the scene, that's when I came to the conclusion that probable cause actually existed to arrest the accused for aggravated stalking.
Did you return back to the scene?
Yes, I did. Okay.
Thank you. Thank you.
Thank you. Hold on. Hold on. Put your hands on your back. Are you serious? Yes. Why is that? You were served with that order. Wow. You were served with that order. Okay? You were served with that order.
Did the defendant ever deny that he was served?
No, he didn't. And it's also on the state system. Okay? So,
Is it not?
ma'am, I want to ask you again,
Can I just show you something, please?
boss,
Sir, can I just show you something?
boss, you probably should have did like you did last time when you came to get property. Remember when you came to get property? I was here.
Can I put my property in my girlfriend's car, please?
No, you're going to jail.
No, I understand.
And you're gonna get charged with aggravated stalking on the family violence.
Are you kidding me? Because
No.
it's been over with?
No, it ain't over with. It's still active.
I have a knife in my pocket, because I can't.
That's fine.
I wasn't
27, go ahead.
Wow.
Do you have any medical conditions at all?
Put it in the front one, in the front one, please. It's going where it's going, but pretty much.
Do you have any medical conditions at all, boss?
Can I get my
You take diabetes, epilepsy, high blood pressure, anything like that,
put
man?
my phone in there?
27,
Yeah, we'll put it on.
stolen on a 2010.
This is amazing.
Just we gotta let the jail know about this night when we get in.
It's okay.
Was there
You're
problem?
taking me to jail. This is amazing. This is amazing.
Boss, the best thing that I can tell you, when you go to court, you may want to hire an attorney so that way you get to straighten out.
This is amazing. Can I make a phone call?
When you get to the jail, yes. All right. Hey, what's this sound like, buddy?
I wouldn't. Wow. This is amazing. This is amazing.
Have a seat.
Even though the TPO was over with, son,
It's still not over. Have a seat.
it was 12 months. I'm not fighting, bro. I'm just
I
asking.
got you. Have a seat.
It was 12 months.
What did you proceed to do after he was placed in the patrol car?
The accused was asking, even though the TPO was 12 months ago, and I kept telling him that it was active, and from there he was being actively resistant with us. So as if the frame would continue to play, we're instructing him to get into the car, and of course, right before we got there, that's when I was telling him you may want to go ahead and hire a counsel to be able to explain the circumstance, because from there, you're going to jail for aggravated stalking. But right here, I'm basically trying to get him in the car. We're all trying to get him in the car. So I opened the driver's side rear door, and that's when I grabbed his left arm just to pull him back and just to keep him secured in the car. So that way we can secure both doors and safely transport him to the East Point Police Department for booking and lodging until he's transferred to the Fulton County Jail for his felony case. Have a seat, boss. Come on, he'll talk to you at the jail.
But it says 12 months. Sir, it said
Have a
12
seat.
months.
I got you. Thank
Wow.
you. Thank you.
It says 12.
Watch your foot.
Please,
Watch your
please.
foot.
27,
Watch
he
your
has
foot.
no warrant for the violence he
Can I talk to you?
You will.
His name is Frank Robert Edward Michael Adam Nora. First name is Lincoln Edward Ida Lincoln Adam 1987-0906.
You want me to get her 39?
I'll get it.
Okay. Sure, because I was going to say just go to the jail because it's extra out here.
You want to go on the thing? Hey, how
Hey,
are you?
good
no
man.
one violent law.
And at this point, stopping at about 9 minutes, 17 seconds to that, essentially conclude your investigation and into this case.
Yes, it did.
All right. In your interaction with the defendant, did you hear him make a comment about how he wanted to show you something?
Yes, he did.
All right. But did you ever review anything from him?
No, I did not.
All right. Do you know what an ex parte TPO is versus a 12-month temporary protective order?
Yes, I do.
What is the difference between the two?
The ex parte hearing is where it's Latin, where one is asking for an emergency hearing. The person that is actually believed to be a victim is the one that's going to be filing paperwork as a petitioner. That person has the ability to petition the courts to testify before a judge, but they have to be able to explain the emergency circumstances, like if there's imminent danger that's present, if there's, for example, like serious bodily injury or death, kidnapping, stalking, anything of that nature, where they're asking for this person, they're asking for some degree of protection immediately. They'll petition the courts, and the courts there's a criteria there, and if they meet that criteria with the courts, a judge that is available that's either on call or present will hear their hearing. They'll give testimony on what occurred, and they'll explain and articulate exactly the facts and circumstances that why they're requesting for an immediate protective order for at least 30 days, which is ex parte. If a judge believes that they met that criteria where ex parte exists, where it's imminent danger, serious bodily injury or death, stalking or kidnapping to that effect, a judge will, of course, just like how I was, swear that person, the statements they're making is true and accurate to their knowledge. They'll sign off on it he or she'll sign off on it on good faith. From there, once it's actually signed, it's the responsibility of the petitioner and us as law enforcement that the respondent has to be served. So in all those cases, the respondent never has knowledge that temporary protective order in ex parte actually exists. So what that means is it's the responsibility of law enforcement, any sworn personnel, to serve the respondent and go through it comprehensively line by line, explaining exactly all what was signed off on, what was initial and what was signed off on, and making sure that the respondent understands what they're receiving. And in addition to that, it's also the responsibility for law enforcement to let that person know, he or she, that you need to gather whatever you need right now and you need to vacate the property. What'll happen is you'll probably get notification by mail, email, or telephone, whatever satisfies the court, where you'll have the ability to actually testify on your behalf on what occurred. If a judge believes that in this particular case that ex parte didn't meet the requirements, he or she will actually dismiss it. If a judge believes that ex parte actually existed and it needed to be extended, then the judge will actually extend it, which will become a further extension of the protective order where it no longer is ex parte.
Okay. And at that point, can a petitioner obtain a 12-month temporary protective order?
Yes.
All right. Now, for this call at the Sir Henry Street address, were you concerned about the possibility that there might have existed a newer ex parte TPO that somehow trumped that 12-month TPO that you had reviewed and confirmed service?
No.
Why not?
Nothing was specifically brought to my attention. Even when I was on the scene, also when I was reviewing the documents, the original documents that I was reviewing, also when the accused was actually asked to walk off, he actually encountered a second officer on the scene. So it took me about a minute to walk away from the scene to review the documents where the defendant was still, or the accused was still talking to the officer. Nothing was brought to my attention when I was checking on the Georgia Crime Information Center. And then when I stepped out of the patrol car to review the documents again, that met my satisfaction. Nothing was brought to my attention at the patrol car. And then nothing was brought to my attention as I was walking back to the scene when I was handing the document back to the caller, until we were instructing the accused to put his hands behind his back because he was going to jail for aggravated stalking.
All right. Now, let's just assume for the sake of argument that Mr. Bryant did have a valid ex parte TPO order, and that is one that had been properly served. What would need to be done for that ex parte TPO to be enforceable in terms of you taking action on it being violated?
So once again, if the accused had a temporary protective order where he's the petitioner and the caller is the respondent, it's my responsibility to be able to verify, go through the documents, just like what I did initially, go through the documents. If he actually has it physically, or in this particular case, if he has it electronically. If he has it electronically, what I'll do is I'll ask either him or her, in this particular case, the accused, to email me a copy of it so I can go and take a look at it. Once I review it, just like I review a hard copy, which I have right in front of me right now, I'll compare the two and I'll do the exact same thing where I'll check now the petitioner, which is now the respondent, through the Georgia Crime Information Center to see if one wants a warrant, two, to see if there's any kind of a protective order that's actually on scene, because the burden of proof is on us and the petitioner that it actually occurred. So if it shows up on the state system, then okay, then there's going to be a possibility where we have two problems. One is the petitioner has one and now the respondent has one, where I'm looking at it as it's going to be double jeopardy. And the reason why I'm looking at it as it's going to be double jeopardy is I can't prove which one is which, even though you may have one at one date and one at another date. That's going to be something that the courts would have to be able to sort out, where if they would dismiss it all the way together and start from scratch.
Well, let's see if we can clear that up. But let's talk about proper service. What would be proper service in terms of serving an ex parte order on a party? Can you just call someone and say, hey, there's an ex parte order?
No.
Can you just have your kids tell you that somebody came by about an ex parte order?
No.
What has to be done in order to effectuate proper and legal service for an ex parte order?
Either us or a sheriff's deputy were responsible for going through this line by line, regardless of how many pages or how many lines. The courts, whether it's the DA's office or even a judge that signs off on it, the expectation relies on us to make sure that we go through it line by line and we simplify it as best as we possibly can. And then we always ask, do you understand? That person says yes, then we'll move on to the next one. If that person says no, we'll repeat it again. And then we do our best to simplify it again where they understand it. We will not move over to the next section until it's actually simplified.
All right, but stepping back from that page by page process, is it fair to say that a person has to have personal service for an ex parte order to be considered served?
That's correct. So that person also has to have a physical copy of it. So what I'll do now is, before I actually had a printer that was installed where I could print it off from the car, we've had it where petitioners only had it electronically, where I went over to the police department, had it emailed to me. I printed 2 copies. One, not only for the petitioner, but also for the respondent, because I want to go above and beyond to make sure there was no doubt and no stone unturned. Or 2, now that I can do it, I'll print a copy and let them know that, hey, here's your copy. So that way, in the event that you do have to go to court, there'll be a hearing. Wait on a phone call, wait on an email, wait on something, some sort of notification from the courts. That way you can present to your side. And if there's any counsel that you want to hire, make sure you keep a copy of this, because counsel will need to review all these documents to make sure that the courts did what needed to be done, where there was a checklist, a proper checklist. So that way, if there's any defenses that need to be brought up on your case, then they could bring up the best degree of defenses on your case. But you want to be able to have some degree of proof to give to them to help your case moving forward.
All right, so proper service has to be personal, is that right?
Yes.
Not a phone call,
No.
not a sheriff's deputy or a police officer dropping it off at someone's house,
No.
and not just calling your kids.
No.
All right. Now, if an ex parte order is not properly served, that is with personal service, will the GBI upload that information to GCIC?
No.
That is, if service is not perfected, will there be a message on GCIC, that system that you interact with in your car? Will GCIC ever show that service has been affected?
It hasn't been properly done. No.
All right. All right, Your Honor, may I approach?
You may.
All right. Sergeant, I'm going to show you what's been pre-marked States Exhibit 10. And if you would, please just take a look at that. And do you recognize what kind of document that is?
Yes, sir.
Okay. What kind of document is that?
It's a ex parte family division document that's filed with the Fulton County Superior Court. It has a.
Stop right there. Your Honor, I'm going to move to tender this into evidence. I'm asking the court to take judicial notice of this document that's been filed in this courthouse.
Any objection to State's Exhibit 10, Ms. Feely? 10 is admitted.
And permission to publish.
Granted.
All right, Sergeant, taking a look at the caption on that document, which I'll share with the jury now. Who is the plaintiff, as it's listed here on this document?
Stuart Bryant.
All right, and who is the defendant as listed in this document?
Malika Thomas.
Okay, and are those the parties that you interacted with and on April 30th, 2021?
Yes, it was.
All right, and what is noted at the top of the document to the right of sheriff's entry of service?
To the
Talking
top.
about what's handwritten.
What's handwritten to the right of sheriff's entry of service?
At the very bottom.
At the top of the document.
You can look on the screen. It may be easier to see on the screen. He's sort of focusing you more on it.
At the top, it has, of course, the address for Malika Thomas.
Okay. Maybe it's not showing on your screen, but at the very top, there's a long line across the top, and on that line there it says sheriff's entry of service. Do you see that?
I do.
And to the right of that, do you see what's written?
Yes, I do.
What is written?
Ex parte.
All right. Now going down to the bottom, what is the date there?
May the 3rd, 2021.
All right. And is a box checked right above that date?
Yes, it is.
All right. And would you read to the jury what that section reads?
Diligent search made and defendant Malika Thomas. Court date expired.
Okay. And then, but what does it say about Malika Thomas under the second line of printed words there? Malika Thomas.
Court date not to be found in the jurisdiction of this court.
Okay. All right. So if you had been presented with this document by Mr. Bryant about some ex parte TPO, would you have felt confident about whether Ms. Thomas had been given proper service of the ex parte TPO?
No.
Okay. And if you had been provided that, would you feel like you would have been able to develop probable cause to arrest Ms. Thomas that day for aggravated stalking, April 30th, 2021?
No.
Why not?
One, it expired. Two, if it's, of course, if it hasn't been on the state system where it actually was signed off on, documents like this is also what we have. But in this particular case, we send it to the Sheriff's Office Civil Division. Once it actually meets their requirement, because they oversee all of this. Once it meets the requirements with the Civil Division, from there, they will send it to the Clerk's Office here at Superior Court, Fulton County Superior Court. And the Clerk's Office will review to confirm that not only did we do what we were supposed to do, but also the Sheriff's Office did their due diligence to make sure that everything was in order from left to right, based off of the expectation of the courts. And they in turn will be able to file it itself with the Georgia Crime Information Center. And that's when it'll be published on the Georgia Crime Information Center, not only for every sworn law enforcement officer in the state, but around the United States to actually have access to.
So having reviewed this document, now States Exhibit 10, do you have some degree of confidence about your decision to arrest Mr. Bryant and not Ms. Thomas that day?
Absolutely.
All right. Knowing what's now in States Exhibit 10, would you have been able to develop probable cause to arrest Ms. Thomas that day?
No.
Your knowledge, did she violate any laws that day?
No.
How many TPOs have you served?
Hundreds.
All right. Now, if a respondent is served personally with an ex parte TPO, can that petitioner go to a residence on their own in order to take whatever action is listed in that ex parte TPO?
No.
Does someone have to join them in their return to that residence?
Yes.
All right. And is the language of respondent is ordered to leave the family residence immediately, and law enforcement, either sheriff or police department, is ordered to assist the petitioner in returning to the family residence and the removal of the respondent? Is that language familiar to you as standard language in ex parte TPO order?
Yes, it is.
And what's the importance in having law enforcement return with the petitioner to the residence to effectuate whatever directive is in that order?
One, to make sure that we maintain peace at all times. Two, to give confidence to the petitioner that the scene is going to be as safe as possible where nothing will happen to him or her. Three, to explain to the respondent that once they're being served, that this is a civil complaint that needs to be addressed in court. We're not the ones that's actually responsible. And I tell them all the time, I don't wear the black robe. And what that means is I'm not a judicial officer. So in order for you to plead your case, the petitioner has to be able to prove whatever evidence they have, whatever witnesses they have. It has to meet the burden of proof, not only with the court, but also with the judge. So you have the ability where you have, if you have any witnesses, any evidence of your own, you can present it yourself. And when you present it yourself, that way, just like us, the judge will evaluate everything and make a decision based off of the entire totality of circumstances. And last but not least, when this case is taking place, I always recommend, I never instruct them to do it, but I always recommend to at least hire counsel and interview them the way you would if you were a business owner. Interview them for the job and see exactly if they meet your criteria or not. And if they answer all your questions and they meet your satisfaction, then give them everything in which you have and inform them that you have a hearing come up, and let them be able to argue for you, because there may be certain language that they understand that you may not, where they can put up the best argument for you. Where in this case, if the judge believes that this needs to be dismissed, it'll be dismissed. Or if it is extended, counsel will give you the best degree of advice on what not to do. So that way you're in compliance with Georgia law and the courts.
It'd be hard to respond to an ex parte TPO if you didn't receive personal service, wouldn't it?
That's correct.
When Mr. Bryant arrived at 3286 Sir Henry Street, was he accompanied by law enforcement on April 30, 2021?
No, he wasn't.
You indicated that there was a lot of chatter on the radio that day. Is that right?
That's correct.
And did you hear anything over the radio that would indicate that Mr. Bryant had requested law enforcement to join him to 3286?
No, I didn't.
Do you have any information about Mr. Bryant even requesting that law enforcement accompany him on that day?
No.
And if he had, would you be able to look on to be able to confirm by checking with dispatch or looking at CAD? And you might need to explain what CAD is.
Absolutely. One, to communicate with the operator that's on the scene. Two is CAD is a three-letter word or three letters that stands for computer aid database. That gives us the ability, like what I said, it's software that's actually attached to whatever computer that you may have, but it's a specific law enforcement sensitive software that we actually have that's actually connected to the Georgia Crime Information Center regarding if we need to check for, like I said, for warrants or warrants, protection orders, or even calls for service. Not only calls for service, but to see who's available for a call and to see who's out on a call.
All right. And the dispatch or CAD, that record of the radio traffic ever indicate that Mr. Bryant had requested law enforcement to accompany him to 3286?
No.
And in your 20 years in law enforcement, have you ever encountered a situation in which a person uses the TPO process to continue a pattern of harassment and intimidation against another person?
No, I haven't.
Okay. You have an opinion about whether one of the parties was doing that in this case?
Objection, Your Honor. Relevance of his opinion?
I'll sustain it for other reasons, but different question.
Okay. Sergeant, from a law enforcement perspective, and this is going to be a bit of a lengthy comparison, but stay with me. Between an unserved ex parte TPO without proper service and a 12-month TPO with the order reading, a hearing was held on this matter on June 19, 2020, for which the respondent had notice as required by law and at which the respondent appeared and or had opportunity to be heard, and information from GCIC that the TPO was served on the respondent and was active, which order would be controlling?
The one where a hearing actually took place and one that is actually documented where the respondent was actually served with the dates.
Nothing further.
So, Ms. Feely, you're up. My hope is we can go till about noon-ish and just take our lunch break because we started a little after 10. So if anyone needs a break right now, it could be super short. If you're able to hold out until about noon, and I'm not limiting your time in any way, Ms. Feely, if we get to noon and you've got more to do, we'll just pause around noon. Everyone doing all right? Good. Let's keep going. Cross-examination of Sergeant Broussard.
Thank you, Your Honor. Can I get states 5?
So all the exhibits are either with the witness or right by Ms. Rivers, and they're all available for you.
That's none of it.
Is it not in either pile? We'll get it for you. What do you think states 5 is?
Okay.
It's a CD,
Okay,
but I
thank
can
you.
pull it up.
No, that's fine. Thank you. You have 6, Sergeant?
Yes, ma'am.
Let me get that. So you testified about you have extensive experience with serving TPOs, right?
Yes, ma'am.
You've served hundreds of TPOs.
Yes, ma'am.
And you're familiar with the data entry for TPO service.
Yes, ma'am.
I'm going to show you what is marked for identification as offense 1. Do you recognize this document?
Yes, ma'am.
And what is it?
It's a Sheriff's Inventory of Service, Family Division, Superior Court. It has a civil action with a case number filed.
So before you get into the contents, as long as you recognize generally what it is, that's sufficient. If this is admitted, then Ms. Feely can ask you about what's in it.
Sure, I recognize it.
And it's the same type of document that the state showed you earlier.
Yes, it is.
Is it a fair and accurate representation of what it purports to show?
Yes, it does.
And at this time, defense would ask the court to take judicial notice of this being a court document that was filed in this courtroom and.
Okay, when you say this courtroom, I don't think it's mine, this courthouse.
In this building.
Okay, all right. Mr. Whitenauer, any objection to defense one? Defense one is admitted and you can publish it or however you want to make it visible to the jurors.
So this is, you mentioned a sheriff's entry of service, right?
Yes,
It's a document that you use regularly.
yes,
And this one, the date is the 10th of March of 2020, is that right?
that's correct.
And this is serving Stuart Bryant, is that correct?
Can you hold on for 1 second? Mr. Whitenauer, can you stop sharing your screen? Thanks. Great.
Serving Stuart Bryant.
Yes, and that case number is 2020 CV 333840, is that right?
Yes,
Date of filing is March 2nd of 2020, is that right?
yes,
And based on this document, it would be fair to say that Stuart Bryant was accurately served, right?
yes,
Effectively served.
yes,
And again, the date of service is March 10th, 2020.
yes.
That's mine. Yep.
I'm approaching now with State's Exhibit 6 as well as Defense Exhibit 1. You can confirm that the case number on both of these documents is 2020 C 333840, right?
Yes,
So this is proof of service of this TPO.
yes.
I'm approaching now with Defense Exhibit 2. Not going into the contents, you also recognize that document.
Yes,
And is it a document similar to the other two documents we previously discussed?
yes,
And is it a fair and accurate representation of that document?
yes,
And we would ask the clerk again to, and we would ask to tender Defense Exhibit 2.
Any objection, Mr. Whitenauer, to defense two?
Yes, Judge, they would object. It's not relevant. They stated after this date of incident, so it doesn't cast any.
Well, let me, if I may look at it.
Yeah.
Ms. Phoebe? Thank you. So I'm confused by your objection. The date that's relevant here on this document is June 22, 2020.
Okay, I'll withdraw that.
Okay, so defense two is admitted. I'll hand it back to you.
That document is also for case number 22 CV 333840,
Yes,
the same order that we've been talking about.
yes,
And this is also to serve Stuart Bryant.
yes,
And this is on June 22nd of 2020.
yes.
Tell us about the conclusion in this document.
The very last line, ma'am. Diligent search made and defendant Stuart Bryant not be found in the jurisdiction of this court. Court date expired this 22nd day of June, 2020.
And so what would you conclude about whether that was effectively served?
Basically says that it actually expired on this particular day. And there's a deputy that basically prints the name and badge number that's basically swearing and affirming that it expired, that it's not valid.
And I think you still have states exhibit is at 10.
Yes,
And that is a similar document, but a separate case number, right?
yes,
And in both of those, you testified on direct that that also was not acceptable service for Maria Thomas, is that right? In the state extent.
yes,
And so similarly in defense set 2, this was not effective service.
yes.
And I also have what's been marked as defense 3. Where's my document?
I do.
And generally what?
It's a petition for a temporary protective order. It's labeled family violence. It also has a heading of Superior Court for the County of Fulton, State of Georgia. It has the names of the petitioner and the respondent, and it also has a civil action number, which is also the case number.
And is this fair and accurate representation?
Yes, it is.
This time defense was moved to your defense exhibit.
Any objection to defense 3?
No objection.
All right, 1 through 3 are all in evidence.
Now, I'm going to again compare the document we've been looking at so we can confirm. This is also case number 2020 CV 333840. Is that right?
Yes,
Petition again against Stuart Bryant made by Ms. Thomas. Is that right?
yes,
And this has a filing date of March 2nd of 2020. Is that right?
yes.
And I'm approaching with defense 1 and defense 3. Again, same case number. Correct.
Yes,
And this is the properly served, I guess, receipt, if you will, or I don't know what the proper term of art is for this document, but it's the documentation that was served.
yes,
And again, that date is March 10th of 2020.
yes.
Okay. I'm sorry.
Now, you mentioned on direct, there being some discussion about the ex parte TPO that Mr. Bryant took out against Ms. Thomas.
Yes,
And so you were aware of the general discussion surrounding that, right?
when you say general discussion, can you explain a little bit more?
Sure. You knew that there was a ex parte protective order according to witnesses on scene.
Yes,
But I think you already testified that you did not look that up, right?
I only looked it up where we confirmed where Ms. Thomas was the petitioner and Mr. Bryant was the respondent, but I did not check where Mr. Bryant was actually the petitioner or Ms. Thomas was actually the respondent.
I'm gonna hand you defense 4. Do you recognize that document?
Yes,
And have you seen that document before today?
no, this is the first that I've seen it.
This is a different case number from the case number we've been discussing, right?
Yes,
And this is Stuart Bryant as a petitioner in this document.
yes,
This is not something that you looked up in your system that day.
that's correct.
I'm going to approach again one more time with state 6. This is again the case number 2020 CD 3333840.
Yes,
And you talked about the language up here of respondent had notice as required by law, which means some mail piece of notice or something notifying him of the court date related to this, right?
yes,
And the respondent appeared and or had the opportunity to be heard, right?
yes,
You were not at this particular court date, right?
no,
You don't know if he appeared and or had opportunities. You don't know which one of those things happened.
that's correct. I did not.
And I think you testified to, it was your understanding that Mr. Bryant did not contact law enforcement the day of this incident, April 30th.
That's correct.
So you're not familiar with the 911 call that Mr. Bryant placed that day?
No,
Not familiar with the 911 call that Mr. Bryant placed from that location that day?
no,
You mentioned a CAD report that would document that, right?
yes,
Those 911 calls are also recorded, right?
yes,
That's all I have at this time, Your Honor. Thank you.
Okay. Mr. Whitenauer, any redirect?
Yes, Judge.
Let's do it.
Yeah, that'd be fine. All right, Your Honor, represent to the witness, if I may, States Exhibit 11, 12, and 13. All documents filed here with the Buffalo County Clerk. And yes, these be admitted and Your Honor, take judicial notice of that.
11, 12, and 13. Ms. Feely, any objection to states 11 through 13? They're admitted.
Sergeant, I'm going to show you States Exhibit 11 now. In this document, who is the petitioner?
Malika Thomas,
Who is the respondent?
Stuart Bryant.
All right. And that case number there, is that the same case number for the TPO that you reviewed in States Exhibit 6?
Yes, it is.
All right. And if you would please read the title of that document in States Exhibit 11.
Order of continuance for service of process, Rule Nisai,
Okay. When is that dated?
23rd day of March, 2020.
So I'm going to show you States Exhibit and you're on permission to publish.
Granted.
And I'm showing now States Exhibit 12. Who's the petitioner in that?
Malika Thomas,
And who's the respondent?
Stuart Bryant.
All right. And what is the date?
It was entered on March the 2nd, 2020, and it's so ordered on May the 8th, 2020.
Okay. And looking at States, and looking at States Exhibit 12, do you see what date the hearing on the ex parte order is reset for?
Yes, I do.
All right. And what date is it reset for?
The 27th day of May, 2020.
Permission to publish.
Granted.
All right. Finally, I'll show you States Exhibit 13. Again, who's the petitioner in this document?
Malika Thomas,
And who's the respondent?
Stuart Bryant.
All right, and is the civil action file number the same in this States Exhibit 13, the same as that in States Exhibit 6?
Yes, it is.
All right, and is there a new date for the hearing in this document, States Exhibit 13?
Yes, there is.
And what is that date?
The 19th day of June, 2020.
All right, permission to publish.
Granted.
And looking at States Exhibit 6, reading the sentence starting a hearing was, what happened on June 19th, 2020?
A hearing was held on this matter on June 19th, 2020, for which the respondent had notice as required by law, and at which the respondent appeared and or had the opportunity to be heard, and the petitioner requested that the protective order entered in this case be continued.
Who's the respondent?
Stuart Bryant.
I'm sorry.
So in the future, we've got a overhead projector, and that's the way we ought to publish documents rather than hand them around. We're not doing the hand around thing so much anymore.
I apologize.
It's all right. It started, and so I figured I'd let it finish.
Yes, sir.
Ms. Feely, do you have any recross of Sergeant Broussard? Okay.
States 12, 13, 14, 14. He still hasn't.
They have it.
When you all have had a chance to look at all those documents, which you will get during your deliberations as well, if they could just come back front and center so Ms. Feely could get them. We got more exhibits coming. Dueling paperwork.
So states exhibits 12, 13, and 14 that you just discussed.
So there shouldn't be a 14. I thought we only got to 13.
11, 12, and 13.
Okay.
Thank you. State's Exhibit 11, as you mentioned, is the order of continuance to perfect service. Is that right?
Yes,
Not proof of service, it's saying there needs to be proof of service, basically.
yes,
And then states 12, the rule 9(I) is basically a notice to appear, right?
yes,
And then states 13, another rule 9(I), which again is basically a notice to appear on a certain date.
yes.
The numbers of your exhibits that you've shared with the state are which numbers?
4, 5, and 6.
4, 5, and 6.
So again, Sergeant, you have a lot of experience with this TPO service situation, which you shared with the jury, right?
Yes,
We appreciate that insight, but you, again, are not in court when these proceedings are taking place, right?
that's correct.
That's all I have, Your Honor.
All right, ladies and gentlemen, do you have any questions for Sergeant Broussard? If you do, pass your questions down into the middle and Deputy Gordon will collect them. Thank you. All right, counsel.
Yeah, use the restroom?
Yes.
Oh. Is that plus?
Yeah, this doesn't have any windows, but at least can get a move around and see.
Okay. Sergeant.
Yes, sir.
The date that you and the other officers responded to the Sir Henry address that we've seen on the video was in late April of 2021. How many days, weeks, months, as best you can recall, before that, was it that you and maybe other officers escorted Mr. Bryant to that address so he could retrieve property? So my question makes sense?
It does.
Okay.
I don't have an accurate timeline, but my estimation is maybe a few weeks before then, because I even tried to look in, had communication to try to pull the call history for that particular call. And of course, the operator could not find the actual call itself, but it was within weeks, because the moment I heard it, again, I knew exactly where I was going. And of course, when you watch the video, you can see instantaneously the reaction I got from Mr. Bryant.
Okay. When you escorted Mr. Bryant on that date, a few weeks or several weeks before the incident we're here for, when you escorted him back to Sir Henry, was Ms. Thomas present at the time?
Yes, sir, she was.
And at any point during that visit, when you were there, law enforcement was there, so Mr. Bryant could get his belongings, were Mr. Bryant and Ms. Thomas less than 200 yards apart?
Yes, sir.
But always with a law enforcement presence?
Yes, sir.
Do you know how a plaintiff, a petitioner, someone who obtains an ex parte TPO, how that person learns, if the person ever learns, that service was perfected?
I know how to get them to start the process, but I don't have confirmed knowledge if they actually perfected the language itself and filled the application out correctly or in its entirety the first time or however many times.
Okay, I got that. I think my question was a little different. I'm getting an ex parte TPO.
Yes, sir.
And it needs to be served.
Yes, sir.
How do I, as the one who got the TPO, the ex parte TPO, how do I learn, if I ever learn, that it got served? Is that your job? You're the officer who served it and you come back to me? Is it the court's job? Or do you just simply not know how that works because you're not in that role?
I'm not in that role, but it's our belief as a whole, collectively as law enforcement officers, that the courts will explain to the petitioner that this has to be served. It can be served by any sworn law enforcement officer. It all depends on the relationship that the court has with the sheriff's office. And we understand even more now on manpower how short it is. We've had it where previously, and I'm speaking from experience, professional experience, where petitioners have said, I can't wait on the sheriff's office forever. They take too long. No one answers my phone call. So when we show up, or when that person shows up or expects us to show up at the house, the biggest thing that they're concerned of is, I don't want anything to happen to me. This person has to go. I need you to help me to serve this so we can get this person out of here. So nothing happens to me or if there's anybody else listed. So then I review it, I'll look at it. And then of course, I'll confirm if that person is there. And the same way how we're cordial now, I do my very best to be as cordial as I possibly can. There may be some degree of agitation once during the process is done, but we do our due diligence to explain it comprehensively to them.
Okay, but that would be the one instance when you would know that the petitioner knew it was served because the service is happening in your presence.
Yes.
You've got the petitioner and the subject, the defendant or whatnot in that petition, and you're keeping the peace while service happens.
Yes,
But beyond that, you don't know how it is the petitioner learns that something was served.
that is correct.
Okay. Did you ever interview anyone the day of the incident we're here for, so April 2021, about the allegations that Mr. Bryant was physical with his daughter, the one with the busted nail?
No, sir, I did not.
Can you explain to the jurors why neither you nor any of your colleagues ever took Mr. Bryant up on his offer / request of, hey, on my phone, I've got a TPO also?
So on the video, Mr. Bryant says, I have something to show you. Nothing was ever indicated to us that it was specifically for the TPO. Had it was stipulated specifically that he was in possession of a TPO electronically, then yes, that responsibility is definitely on us to review it.
Okay, fair enough. And in fact, the question says, why didn't you listen to Mr. Bryant when he tried to tell you he needed to show you something on his phone? So let me ask it that way rather than guessing what the something was. So there's a situation and the person you're taking into custody is saying, well, I need to show you something on my phone. Explain to the jurors the investigative decision, why you made that investigative decision to say, I'm not going to look at what's on your phone. You're coming with me.
So once I got there, I usually do my very best to let the officer handle the call. One, to make sure that it's in compliance with what the courts expect and the prosecutors expect, even counsel and policy. If I see anything that deviates outside of that, then I'll intervene and I'll, take over just to make sure that we're all in compliance. In this particular case, when Mr. Bryant said he had something to show, and I think had there been a little bit more patience initially, I think it probably was conveyed. But then again, when the third officer showed up or the second officer showed up, which was a total of 3 of us, once he had the opportunity to speak to the other officer, when it was just a one-on-one conversation, it was under my belief that Mr. Bryant had the opportunity right then and there to explain to the officer because he understands what's required. I believe that had Mr. Bryant explained to the officer right then and there, the officer would have brought it to my attention immediately and said, hey, whoa, we need to slow down a little bit. Here's what we got right here, because the responsibility is going to be on us to sort it all out. And had I recognized it right then and there that Mr. Bryant actually had it, then of course, like I said before, then in my opinion, it would have been double jeopardy, where there's no way that I can either arrest both of them because of what's going on. That's going to be something where the courts are going to have to hit the reset button and have everything come back to court and make a final decision on who's actually the petitioner, who's the respondent, what's going to be the final order, what's the final outcome, as far as if it's going to be granted, who is who.
Okay. If you encountered a situation where people had cross TPOs, but the evidence as you understood it to be was that person A came to make contact with person B, even though they have cross TPOs, could you conclude, based on what I'm learning at the scene, person A is violating a TPO because person A came to person B, in the same way that person B could be violating if B went to A. But if the evidence you're presented is that A came to B and they both have TPO saying stay away from each other,
right,
how would you handle that rather than saying double jeopardy? Gosh, they're 2 TPOs. How would you process that?
Okay, so what I would do is I would document and explain to both that I'm not comfortable making an arrest right now. I'm a firm believer that the burden of proof is here and I'm doing everything on good faith. I'm going to document it comprehensively. I'm going to get copies of it, of both orders. From there, I'm actually going to give it to a detective to actually follow up with the courts and all parties that are actually involved to confirm what's going on. Once that actually happens, if I'm pretty sure the courts here have advocates that are that help petitioners on cases, try to get a detective to network with the advocate and go from there and explain, like, here's what the officers on the scene had. They were not responsible, or they're not comfortable making an arrest on the scene based off of what they had. Is it possible you guys can help both parties to really re-petition the courts to really have this rectified, where there's the best understanding for everybody involved. And I think it would have been, where we explained to both parties, not together, but separate. If we explained to them separately, like, listen, I wasn't present when this order was signed. I wasn't present when this order was signed. However, we are not comfortable arresting this one because I want to be able to say that I was fair and I was balanced on this case. This right here is not allowing us to be fair and balanced whatsoever.
Okay. Last question from me, from the jurors. You described at one point during your testimony the process you have to go through reading line by line of a TPO, every line of it, to make sure that the person in that situation understands what's in the TPO.
Yes, sir.
Is that when you are serving the TPO, or is that when you are arresting someone because you believe that person has violated a TPO?
I do it on both. More so on ex parte when I'm serving the respondent. I know that there's going to be certain questions that that person may not understand, but I do know that the burden of proof is on us in the event. You may have some that are going to violate the order. You're going to have some that will not. But if I could do my very best to explain to them, this is what the order is saying and what consequences could actually occur. But I want to make sure that I simplify it as best as I possibly can.
In this scenario where you're serving a TPO on the subject of the TPO.
Yes, sir.
But you say you do it in both. So in this case, when you took Mr. Bryant into custody, did you go line by line through the TPO that Ms. Thomas had handed you, or was it a summary, or what do you recall that you did consistent with what you just described?
So when I go through it line by line, I go through it line by line to see if with the respondent, if there's any kind of a violation. I won't discuss it with them line by line personally. The only way that I will discuss it personally is if it's ex parte, now they're being officially notified that they're the respondent.
Okay, so you reviewed it line. This was when you're at the hood of your car and the thing is unfolded. You're reviewing it, not with Mr. Bryant saying, "Okay, come over here. Here's line 1, here's line 2, here's line 3.
That's correct.
You do that to confirm, if you are able, that in fact there was in your mind a violation of it, and so someone's going into custody.
Yes, sir.
Okay, thank you.
Yes, sir.
Mr. Whitenauer, any follow-up?
Yes, Judge. Thank you.
All right. The judge, I gave an example of A coming to B. You remember that?
I do.
In this case, who was A coming to B?
A was the respondent coming to B,
Who's the respondent?
the respondent is Mr. Bryant.
All right. And who is B?
B in this particular case would be Ms. Thomas, who's the homeowner. And because she's B, she's the one that's actually calling us to respond.
Okay. And did B, Ms. Thomas, on April 30th, 2021, have an active 12-month TPO against A, Mr. Bryant?
Yes.
All right. And is state 6 up there?
No.
It's a lot of paperwork moving around right
A lot of
now.
paperwork. And do you recall in state 6 that 12-month protective order reading that a hearing was held in June 19, 2020, and the respondent had notice? Do you recall that?
Yes.
All right. And in contrast, Mr. Bryant's ex parte TPO, had that been served?
No, I didn't see anything that remotely relates that it was actually served to Ms. Thomas.
Nothing further. Thank you.
Ms. Feely, any questions for Sergeant Broussard based on what we covered? Okay, Sergeant, thank you so much for your time.
Thank you, sir.
You are free to go.
Thank you.
Ms. Feely, I want to make sure I documented, you admitted 1 through 3, also 4 through 6, or those were documents that you shared with the witness, but they weren't admitted?
I think that's correct, Your Honor.
So defense 1 through 3 is what you believe. I know those were admitted. I wrote that down. That's as far as you went in terms of actually tendering documents. Okay. All right. Mr. Whitenauer, next witness.
Stay rest.
All right. Ladies and gentlemen, we are at a natural and healthy break point. I appreciate you sticking around an extra 10 minutes, but I thought it would be good to wrap up Sergeant Broussard's testimony so that he could just go and not have to come back after lunch. let's see if we can, if we try to get back together pretty close to 1, will that be enough time? So not quite an hour. It'll be all right if someone is a little bit after 1 getting here. Not that I looked at anyone. But aim to be back by 1. This is our first lunch here. You are welcome to go get lunch and bring it back. You're welcome to have lunch away from here. And it is fine for you guys to eat as a group or subgroups. Just don't talk about the case while you are having lunch, and don't do any outside research. The state has rested, so we have closed 1 chapter of the proceedings. But when we get back from lunch, I'll be asking Ms. Wood to call her first witness, and she may call witness X. She may say the defense rests. And if it's witness X, we're still going with evidence. If she says the defense rests, then you have in fact heard all the evidence. We'll turn to closing arguments, and then finally, you'll get the charge from me and you'll be in a position to deliberate. All right. So let's try to be back around 1 and we'll get going. Thank you so much. All right, you all can be seated. Ms. Wood, any motions from the defense before we break?
Yes, Your Honor.
Ms. Feely?
Who has one?
Okay,
At this time, move for a directed verdict on count 1, Your Honor.
all right, and the basis for that?
The evidence that has been submitted so far, do not show that Mr. Bryant had any notice of the date prior that this TPO was not in fact expired. He was served, as was just testified to, in March of 2020 with a 12-month. And then the evidence was that he was not served properly in June and did not.
Hold on 1 second. They're locked in. You believe the evidence shows that, or there is no evidence showing that Mr. Bryant was served with, and I think this is part of what's confusing for me, there may have been an original protective order and then not the 3-year extension, but there was an extension that pushed it past whatever date in March Mr. Bryant seemed to be keyed in on, hence his appearance in late April at the house.
And so while bizarrely, there is not a notice requirement listed in the statute, I think it's a due process issue that he is being accused of violating, in fact, a felony violation of an order where there is not any evidence that the state presented that he actually had a copy that showed that it did not expire in March.
Okay. Mr. Whitenauer, what is the state's evidence showing that Mr. Bryant was on notice of what we'll call version 2.0, if the 3-year extension is 3.0, version 2.0 of the protective order? And I will acknowledge up front, there were a whole lot of pieces of paper flying around with poor Sergeant Broussard, who was clearly just I'm a warm body, and the court is taking judicial notice of all these different service things. So it may be as simple as you saying State's Exhibit 11, but I'm curious to know what you rest on as being some evidence, because that's all you need for the jury to think that Mr. Bryant was on notice of version 2.0.
And you're talking about the family violence 12-month protective order.
So
Your 2.0, sorry.
there's some document that seemed to have a date range that didn't extend into June of 2021. And then there is a document that has a date range of June to June, June 20 to June 21. That's the document I believe you're relying on as the TPO. So why don't I just say that? What is the proof you rely on that Mr. Bryant had notice of the June 20 to June 21 TPO?
So first, I'd respond that notice is not required. And I'd cite to Presley v. State. It's 307 Georgia Court of Appeals, 528. It's a 2011 case.
What were the last 3 digits?
528.
Okay.
And That case, and I have copies for defense and
I'll look it up. That's fine.
okay. In that case, the defendant Presley argued that the trial court's jury charge on aggravated stalking was unconstitutionally burden shifting. The court said it disagreed. It wrote that a person commits the offense of aggravated stalking when such person in violation of a temporary protective order follows, places under surveillance, or contacts another person at or about a place or places without the consent of the other person for the purpose of harassing and intimidating the other person. After instructing the jury in accordance with the foregoing and defining the harassing, intimidating element of aggravated stalking, the trial court charged the jury as follows. Georgia's aggravated stalking statute requires proof of a court order restricting contact by the defendant with the victim and a violation by the defendant of that order. The existence of a written order is presumptive evidence of notice to the defendant in an aggravated stalking case. And in reviewing that language, the court held that that charge was appropriate. Concluding that the court's instruction that the existence of a written order is presumptive evidence of notice to the defendant was not harmful as a matter of law. Your Honor, in any event, we would argue that even if he didn't have notice, the fact that he, according to State's Exhibit 7, this family violence 12-month protective order, which was signed and dated by the judge who heard the matter, that this document indicates that he did have due process of law, that he was provided, that one, he appeared and or had the opportunity to be heard. And so the written words on this document address the argument by defense counsel that there was no notice. And then also, of course, Presley addresses the fact that notice is not required, but that this written order is presumptive evidence of notice to the defendant in an aggravated stalking case. So we'd ask that you deny the motion for directed verdict.
Okay. But it doesn't sound like amongst the exhibits that were admitted during Sergeant Broussard's testimony that there is a proof of service of the June to June TPO. Is that correct?
The June 2020 to June 2021?
Correct.
Well, Judge, I note that Ms. Thomas testified, stated that Mr. Bryant was present, but to answer your question, no, there's no documents that have been admitted that shows that has shown service.
Got it. So we've got Ms. Thomas's testimony saying, oh no, Mr. Bryant was at the hearing when this order was entered. The order indicates that either he was present or he had an opportunity to be heard, that and or is a little tricky for the state. And then you're relying on Presley. Okay. Got it. I'm going to read Presley, Ms. Feely, over the break. Anything you want to say in response?
I do encourage the court to read Presley because it's not even what we're talking about. It's talking about a jury charge not being plain error, which does not mean it wasn't error. It just means that particular standard wasn't met. But and that is for the existence of the proposition that the existence itself of the TPO is presumptive evidence of notice, and that's the only case that even goes there at all, and it is in the context of a jury charge, not for purposes of what the evidence is. I think it's a misstatement of the law, frankly, that just the existence of something is proof that of notice to another person. But so I would encourage the court to take a look at that case
Okay.
as well. The only other thing I would point out, Your Honor, is Ms. Thomas also testified that he was present at some hearing, but I don't know that she was clear what date that hearing was. But she did also testify that Mr. Bryant was getting mail delivered to the family home and that she doesn't know what it was and she wasn't trying to forward it to him. And so if that's what they're relying on for notice, I think that is not going to be due process type of notice to be charged with a felony.
Got it. Okay. I will take this under advisement and let you know what we're going to do when I get back, when we wrap from the lunch break. I do want to, though, so folks can plan for it, figure out what's coming after lunch. So I need to ask you a few questions, Mr. Bryant. You ready?
Yep.
Do you understand, Mr. Bryant, that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Understand.
Do you understand that in the same way, no one can compel you to testify, meaning you have an equal and opposite right to not testify if that's what you want to do? Do you understand that in the end, it's you and not your lawyers who will be deciding? I'll be asking you at the end of this exchange we're having whether you want to testify. I won't ask Ms. Wood. I won't ask Ms. Feely. You understand? Do you understand that if you choose not to testify, I will tell the jury that that decision cannot be used in any way against you? Do you understand that if you choose to testify, you will, of course, answer all the questions from Ms. Wood or Ms. Feely, but you'll also be subject to cross-examination from the state. You don't get to say, oh, I take the fifth, or I don't want to answer. Those are hard questions. You answer every legally proper question from both sides. You understand? Okay. Understanding those things, Mr. Bryant, are you electing to testify in your case? All right. I find that Mr. Bryant has made his decision to testify with a full understanding of his rights, and that will be the plan. Ms. Wood, do you envision calling any other witnesses besides Mr. Bryant?
No, Your Honor.
Okay.
And just as a housekeeping, just because I haven't done it before, we are going to attempt to tender a 911 call that's on a disc. What's going to be the easiest way to do that?
You're going to need to figure that out over the break. All right. Let's be back around 1 o'clock. And I need all of you to step outside the courtroom so I can deal with the other matter that I've got.
Let me take my stuff.
You can leave your stuff, but yourself needs to go outside. Okay. We're back on. Mr. Whitenow, are you ready?
Yes, Judge.
Ms. Wood?
Judge, we do have one matter I'd like to address before the jury's spread out.
Great. I need to address the motion for directed verdict as well. What's your matter?
Mr. Bryant has elected not to testify, Judge.
Okay. Mr. Bryant, we'll cover that in a minute. But I do want to have a good exchange with you on that change, which is fine. But in a minute. First, I've read Presley, and I don't know that either side quite framed Presley as I read it. I think, Ms. Feely, it was helpful for you to bring to my attention that it was not a particularly favorable standard of review for Mr. Presley on appeal because his trial counsel did not object to, actually, right next door, Judge Brasher. He's been in that courtroom the whole time he's been a judge, so it happened right next door. He gave the jury charge that is the language that Mr. Whitenow was pointing out, which right now is not a requested jury charge. But what the court in Presley quotes is not the jury charge. It quotes another Court of Appeals case that stands for the proposition that proof of the written order, the protective order alone, is sufficient to prove notice was provided to a defendant based on the presumption of regularity in judicial proceedings. So that's Presley with one S versus State 307 Georgia Appeals 528 at 531. And that magic language, proof of the written order is sufficient to prove notice based on the presumption of regularity, is itself borrowed from a case Revere versus State 277 Georgia Appeal 393. So it's not quite right to say there was language there that was never used. It is correct that Presley is not cited by any subsequent appellate court case, but it was relying on a different appellate court case that stood for the proposition that proof of the written order alone is sufficient to prove notice. And this opinion also notices, that's the wrong word to use, observes that notice is not an element of the crime. That being said, there may well be some powerful due process arguments that could be made on appeal, if there is an appeal in this case. I find that there is some evidence, and Mr. Bryant, you should know that one, Ms. Feely made a very strong motion, but two, the standard that I have to apply to a motion for directed verdict is very much in favor of the state, because I am in favor of the state, is what the law says. I should not grant a motion for a directed verdict if there is any evidence, any A-N-Y evidence upon which a guilty verdict could be supported. I have to assume, for the purposes of just this analysis, that the jury is going to view things as favorably as possible to the state's case. They may not. They may, based on the jury questions, it sounds like they are hung up some on this question of what did you know and how would you have known and how could you have known. But I think if we combine Ms. Thomas's testimony that Mr. Bryant was present at the hearing, and I agree it's not clear which hearing we're talking about, but a jury could conclude it was the hearing where Judge Manning signed what I'm calling the June to June TPO. We couple that with Broussard's testimony that he ran the TPO through the system and it indicated it was valid and notice had been provided. And the language in Presley as borrowed from Revere. And I think there is enough to get to the jury. There's no question that the record is muddled, and that is not an attack on the state's presentation. It's just that there are multiple orders, who was served, who wasn't. That's less clear. And I think that the defense has a very, very good foothold in arguing about that, but it is not such an overwhelming position that the defense has that I could properly find that there is no evidence that the jury could rely on to conclude that Mr. Bryant was aware of the order, coupled with, I think the state of the law is it kind of doesn't matter that he didn't know. I don't know that that's proper law, but that's what these opinions seem to hold. And so if there is a conviction that gets appealed, maybe there'll be a Bryant versus state that clears up this odd due process situation where an order about which someone knows nothing could be used to put him in criminal jeopardy. So I'm going to deny the motion on those grounds. Mr. Bryant, you and I had a good, I felt it went well, conversation. You understood your rights very clearly about the right to testify and the similar right to not testify. The consequence of choosing to testify subject to cross-examination and potentially in your situation, depending on answers you gave on direct exam, the jury learning about your misdemeanor convictions. You also understood, I found, that if you choose not to testify, then I will instruct the jury that that's effectively a non-event. The jury is not to consider that in any way, shape, or form that would be in any way harmful or hurtful to you. And that's precisely what I'll do if you choose not to testify. Now, before we broke for lunch, excuse me, you told me with some vigor that you were going to testify. It's your decision and not Ms. Woods or Ms. Bassett's or welcome, Ms. Evans. I don't know that I saw you earlier today, or Ms. Feely's. It's yours and yours alone to make after you consult with anyone and everyone you want to consult with. And you told me before lunch, by golly, Judge, my words, not yours, you're going to testify. Ms. Wood is telling me that you may have had a change of heart, which is fine, but I need you to make plain and clear on the record where your heart and mind are now in terms of testifying, because about 30 seconds after that, I'm going to bring the jury in and ask Ms. Wood to call her first witness. And if Ms. Wood says the defense rests, then you cannot change your mind and say, wait a minute, I know they're deliberating, bring them back out here. I got some things I want to tell them. Does everything that I just said make sense to you? Yes. Understanding what I just said to you, Mr. Bryant, have you decided to change your mind? And after all, you are not going to testify?
Yes, I've decided to change my mind.
Okay, and so your election is to not testify.
Yes.
Got it. Then I will tell the jury about that fact, meaning not that you elected not to testify, but the fact that you didn't is a non-event for them. And it's the language that you all have seen in the draft charge that I shared. Ms. Wood, is there anything else you want to cover based on that announcement from your client? Okay, Mr. Whitenauer.
Yes, Judge. So I recall you saying that the state had requested language on the issue of notice, and I did ask that it be included. Is Your Honor not inclined to include that language in the jury charge?
No, it may well be that you did. Ms. Niles flagged a few things that she didn't include because she was confused or wasn't quite sure. And I flagged one of them yesterday about a family protective order, and that doesn't seem to have caused any heartburn that I kept that out. But tell me, let me get into the directory. That's not it. Brian.
I mean, it was not a pattern.
Doesn't need to be a pattern, but it's something you requested?
Yes, Judge. May I move about while you're doing that, Judge, just to look at some of the exhibits?
Yeah, that's fine. Okay, I see. I did not include this. I'm reading from Ms. Niles's email, this non-pattern charge of the state because Ms. Niles is sending a instant message at the same time. All right, thank you, Ms. Niles. She's not even in the office. This is scary. If notice becomes an issue, you may want to add the notice part. Got it. All right, so was your request effectively, Mr. Whitenauer, to include the language from Presley that is the quote from Revere, proof of the written order alone, and I would tweak it a little bit, but basically paraphrase that quotation that was lifted from Revere?
Right, from Revere, Judge. And,
Okay.
And thank you for flagging that.
Okay.
Because I do think that notice has become an issue, and
Yes.
and would help the jurors understand what the law is.
Is the court going to type that language out on the chair screen?
Yes, ma'am. Yeah, I won't make you guess what I'm thinking about saying. All right, so actually 5 cases, just so we're understanding the strength of the law here. There are 5 Georgia cases that rely on that point from Revere. And I'm going to look at the most recent one because Revere is from 2006, but Branch versus State is a 2021 case. It is 1 year and 22 days old.
Just trying to make sure we have things that are live.
So Branch 361 Georgia Appeals 86 cautions courts not to engraft an additional element to aggravated stalking of service or proof of service. So I will not so graft that, and they use the word engraft. I will not engraft into the statute that service element. And then Branch goes on to quote Revere for that same proposition that is in Presley. Even if notice of the order were required, proof of the written order alone is sufficient to prove notice to Branch, in brackets, based on the presumption of regularity in judicial proceedings. So let me see what that looks like for us. All right, if you all would look at the screen. So the highlighted language is what I have drafted. I'm open to proposed edits, and that flows from Branch, Revere, Presley. Branch cites a bunch of other cases, including a Supreme Court, well, ignore that Supreme Court case. Well, that stands for a general proposition that you have to follow the statute and can't add elements to it, trial court judge. That's a very important point, but it is not specific to ag stalking. So it's Court of Appeals cases that we're working through here. Anyway, if you all look at that, I'll start with the state, Mr. Whitenauer. Does the highlighted language, which I will unhighlight for the final version, does that make the point you think the case law stands for?
Yes, Judge.
I think I'll make it clearer. I'm happy to reword it in some way if you think it will make it clearer.
I could make suggestions, but I think it'd be differences without much distinction, Judge.
Okay, all right. Ms. Feely, apart from the overarching objection that for due process reasons, this is burden shifting is really the wrong term, but well, maybe it's the right term. You're going to make the argument, and I want you to flesh that out, but you don't need to go too far with it because I think you've already made a record that you think there's a flaw in the law. And why should we incorporate it here in the jury charge? But having looked at Branch and Presley and a couple of the other cases, I think this is a proper statement of the law. I mean to have it be a proper statement of the law. And if there's a way I could word this differently that you think more accurately reflects the state of the law, I'm happy to consider that.
So I feel more comfortable. Well, first of all, yes, we object to the whole thing, obviously. I do think it's in the statement of the law, and I think it is burden shifting.
Well, let me pause you for a second. What am I misstating about the law? If you look at somehow you were able to read Presley on the fly. So if you read Branch, I do not want to misstate the law. And what I heard you to say is, in essence, my words, not yours. I don't like the law because it's in error, because it creates due process questions. How could someone be held criminally liable for something he doesn't know about? And that's the thrust of the argument that you made here, that you might make at a higher level if there's an appeal in this case. But I'm bound by Branch. And I think that Branch states pretty clearly that if the state shows that there was a written TPO, then the state doesn't have to prove actual notice. So I don't think this misstates that point that flows directly out of Branch. But if I'm all mixed up on that, I'd like to be straightened out.
I haven't read Branch, but I thought Presley was the existence of a TPO as presumptive evidence of notice, not that it just completely allows the state to not have to prove that there was any even attempt at, because the presumption we have overcome, I would argue, with actual document that's in evidence showing that service was attempted and not made. So I think presumption of is bad enough, but it's
okay. So you should look at Branch.
May I have the site again, Judge?
Sure. It is 361 Georgia Appeals 86, and in it, Branch points out that there is no requirement of proof of service. So that if you go to I don't know what they call those, head note 4, but in the text. As for service of the court's protective order on Branch, the aggravated stalking statute does not include service as a necessary element of the offense. And it quotes the whole statute. That's then when the court says, you better not engraft onto the statute this additional service element because it's not there, quoting Revere for the first time. Jump down to the next paragraph. Moreover, in this case, as in Revere, the protective order was admitted into evidence. So even if notice of the order were required, which it's not, my editorial, proof of the written order alone is sufficient to prove notice to branch based on the presumption of regularity in judicial proceedings.
I think that's what's missing, based on the presumption, because we can rebut the presumption. So I think if the court's gonna give this, we need that language in there also.
Okay, so what language?
That last clause at least. I'm not able to pull the case up readily, but
I don't think there's a pattern jury charge for that.
in Branch, I thought there was evidence of personal service.
So no, there was evidence that Branch had been informed of and knew about, but not that there was necessarily service. So the court found that there was evidence that Branch was aware of a court order in place, not that he was necessarily served. But they don't reach that. I mean, Branch isn't unclear. It is not vague language.
The reference, whenever the court's ready,
I am ready.
in Branch to him being personally served is right above head note 4. And it says, the trial transcript shows that the state introduced without objection to sheriff's entry of service documents indicating that Branch was personally served with a petition and summons prior to the hearing.
Okay, but then read head note 4. I mean, the language of head note 4 is all about, that's fascinating, but it's not an element. I'm sorry having to read that on a phone screen. Okay, how about this? Let me share a different screen so you can read it in bigger. There. I don't know if that's bigger for you. And I didn't highlight that. That pops up when you go to Branch from Revere.
So we would prefer the language of this. Proof of the written order alone is sufficient to prove notice to Branch based on the presumption of regularity in judicial proceedings.
Can you move your microphone closer to you?
I understand your request. I think the way I read Revere and Branch is that Revere was explaining and Branch is echoing the reason why proof of written order alone is sufficient to prove notice is the presumption of regularity. I don't know that we help the jury a whole lot by using the phrase based on the presumption of regularity in judicial proceedings. I don't know that they're going to know what that means, but what I don't want to do is prevent you from arguing in closing, hey, there's this presumption, but we've rebutted it. I don't know what you felt was irregular about the judicial proceedings, but the way I'm reading Revere and Branch is that the Court of Appeals is telling trial court judges proof of written order alone is sufficient to prove notice, full stop. But they're explaining why they say that. They say that because there's this presumption of regularity in judicial proceedings. What is the irregularity that you would point to?
The fact that we tendered a document that shows that in June, he was attempted to be served and was not served. So there is affirmative evidence that he was not, in this case, served. So I think that part of the presumption needs to be added.
Okay, Mr. Whitenauer?
Well, so I disagree with the statement that there's affirmative evidence that, well, I understand that those documents show that service wasn't, I would agree that those documents show that service could not be effectuated. I don't know that those documents show that there was an irregularity in judicial proceedings. There were attempts to provide notice to this defendant on several occasions. And then, of course, there's the order, state 6, that's been admitted that states there was a hearing, he was present, and he had the opportunity to be heard. So I think the evidence is that there were regularity in proceedings. And so I don't know that that's something that, and also I think this is a general comment about our judicial system that things are done as they're supposed to be. We can assume that, and including it might make the jury think that the state also has to prove that there's regularity throughout the system.
Right. So I agree with that. You put it better than I did. I don't think first of all, your proof of non-service is in evidence, and you're gonna be able to talk about that. I don't think non-service would be the irregularity in judicial proceedings. That's not how I'm interpreting that phrase, because I don't think service is judicial proceedings. I view the judicial proceedings as in, if there's a written order, we presume that a judge would not have issued that order without having respected the due process rights of the defendant to be present and or represented, whatever it would be. That's how I interpret the regularity of judicial proceedings, so that the notice would flow from the presumption that notice was given would flow from that proceeding that yielded that order, and not the ancillary procedural aspect of was he served or not. So I hear your request, but I'm not going to put that language in there because I don't think it refers to the piece of the process that is service of process.
Sure. And I wanted to also put on the record that this was June of 2020, and COVID also could have affected all of the proceedings, including notice and what Mr. Bryant should have been aware of at that time.
No doubt. Okay.
That's a due process issue as well. If we could see what the court plans to give one more time.
Sure. Oh, right. It's on my screen. It's not on yours. I'm going to add this. Because I don't think it's enough to say, hey, that because of the facts of this case, the jury may find, yeah, the one that we think is valid is the one that was March to March. And so I think that last clause that was enforced at the time the contact allegedly occurred, that the jury may, because of what you pointed out about the non-service of the June to June one, they at least need to be thinking about that. Anything else you want to add in terms of your objection?
I think we covered it, the constitutional Fifth Amendment, 14th Amendment, burden shifting. But then also, Your Honor, we are going to have to request the knowledge pattern charge as well.
Okay.
I think,
Can you get me that language?
yes, it's pattern knowledge on the part of the defendant that the
So
crime.
no, I need someone to email me the language.
Got it. Yeah.
Deputy Gordon, will you let the jurors know that we are hard at work? We're not ignoring them. We're working through a legal issue, please. Thank you. Got it. Thank you.
Oh, that actually, it was another page. I'm sorry.
You don't like that knowledge one?
No, I do. Making sure. Yeah,
Another
there's
part to
another,
it,
there's
Judge.
more paragraphs.
More
No,
paragraphs.
I know, I know.
Are they rioting or they're okay?
They're okay.
All right.
I'm going to send the whole thing again, Your Honor.
Okay. Of course, this is from Shubo. All right. Wait, what's the actual pattern charge? There's some citation at the bottom. Is this the pattern charge or is she trying to pull something out of a case?
It's the pattern.
All right.
We have to be able to show him some laws, case on incorporated pattern. So.
No, not that you're going to share.
I just couldn't get out of this issue. Wait, the USB.
All right. You also look at the screen. I'm going with the one sentence version. I don't repeat just as a matter of form because it's true about intent. It's true about identity. It's true about all these things. If the jury doesn't find that the state has proven beyond a reasonable doubt that the crimes occurred in Fulton County, they must acquit. If, however, they find by a reason beyond a whatever, then they may convict. The important part of knowledge is the sentence that is in there taken from the pattern. And that will appear at the bottom of page 5. Do you have other additions to the charge based on the exchange we've had about notice, Ms. Feely?
No, Your Honor.
Okay. Mr. Whitenauer, anything you want to add?
I'm just reading the sentence, Judge. Slow counter, slow reader.
Okay.
No, Judge.
Okay, so that is in. I removed the charge about prior convictions. I removed the highlighting from, but left in defendant's choice not to testify. And otherwise, it is as we discussed. All right. Anything else before we bring the jurors back in, Mr. Whitenauer?
No, Judge.
Ms. Wood?
No, Your Honor.
So then what will happen is they'll come in. I'll ask Ms. Wood if the defense has any witnesses to call. It sounds like you're going to say the defense rests. Evidence is closed. Are you planning on opening and closing with closing, Mr. Whitenauer?
Waive and close.
Okay, so Ms. Wood, Ms. Feely, Ms. Bassett, Ms. Evans, one of you is ready to give the closing argument for the defense.
Ready, Judge.
Excellent. Do you need any equipment set up or you're good to go?
I have it on Zoom, so I can just screen share.
Excellent. Let's bring the jurors in, please. Spotlight.
All right, so juror.
Some heads. Thank you, Deputy Gordon. You all can be seated. Ladies and gentlemen, appreciate your patience. A couple things came up. One, we had to work through more than I had allocated time for, so bad time estimate on my part. Some discussions about the charge that I'm going to give you later this afternoon. In other words, the law that you need to receive. It got a little complicated because of the way some of the evidence has played out during the course of the trial. And then number two, no one in the room's fault. I am also the judge who presides over the special grand jury that you read about from time to time. And there was an issue with the special grand jury. When they come in, everyone has to leave the courtroom and we sort of go top secret zone and talk about what's going on with that special grand jury. And that delayed us a little bit as well. So I apologize. You were back by one as you committed to. All of you were, and that is good. But we made a lot of important progress. When you broke for lunch, Mr. Whitenauer had announced that the state was resting. And so it is now appropriate for me to ask Ms. Wood if the defense is going to call any witnesses. Reminder for about the 10th time, defense has no burden at all. Ms. Wood may say, yep, we call and they start, but they also may rest because they don't have an obligation to prove anything to anyone. Ms. Wood, call your first witness.
Thank you, Judge. The defense rests.
Okay. Ladies and gentlemen, the evidence in the case is closed. You have seen and heard all that you're going to see and hear that is evidence. All the exhibits that have been admitted will likely go back with you. We'll need to have a discussion, the lawyers and I, if there's an exhibit that needs to be redacted in any way. But assume you'll get those. You've heard all the testimony. There are two parts left before you begin your deliberations. Number one, the closing arguments from the lawyers, where they will argue to you what they think you ought to do. They will try to persuade you, perfectly appropriate for them to do that. But reminder, if lawyer X says, and this is what the witness said, and that is not your recollection, you can choose to be persuaded by that. But in the end, it's your recollection of what the witness has said and what the facts are in this case. But these lawyers are in a good position to connect facts with law. They know the law I'm going to give you. You haven't heard it yet. And it's fine for them to talk about the law while they're working through their closing arguments. Because the state has the burden of proof, the state has the ability to open and close, go first and last, say what they want to say, hear what the defense says, then have the final word. Mr. Whitenauer has shared with me that he is reserving all his time for just a final closing. So the defense will go first. And when the defense is done, then we'll hear from Mr. Whitenauer. And then you all will hear from me about the charge that you're going to get. Okay, with that, Ms. Wood, when you're ready, please.
Ms. Feely,
Oh, Ms. Feely, all right.
Judge, may I go ahead and share my screen?
Yes, I think I've unshared, so yeah, you share away.
Just double checking.
things are not always as they seem. But Ms. Wood told you in opening, and that is what has played out in this trial. When you walked in here on Tuesday, you saw Mr. Bryant, and all you heard was this indictment against him. It sounded bad. It sounded awful. Then you heard that he pled not guilty. And it wasn't until the state started having to prove things, what the state's evidence was, what their witnesses had to say, that you started to understand why this Wood told you in opening that things are not always as they seem. Mr. Bryant is not a bully, as the state said in their opening. He's not intimidating or harassing. He's a man going through a messy divorce, as you heard, with a woman who uses the system against him. And that is what she's asking you to do in this case. As Judge McBurney said, this is my last chance to address you. So I am going to talk about the law also.
Bad clicker.
I've got one. You want to use mine?
It looks like it's working.
Oh, okay.
So much. Thank you.
Yep.
So what you heard was that on the body cam that the state presented, that Mr. Bryant thought the TPO against him was expired. He thought his TPO that he took out was active, and he did not go to his house with the intent to harass or intimidate.
You want to try?
Whoops, you just took it off the slideshow. If you hit F5, it goes to slideshow.
Okay, this is the part that I wanted to address with you about the law. So the state, as you've heard, bears the burden of proving every material allegation of this indictment and every essential element of each crime in it. That burden never shifts to Mr. Bryant to disprove anything. If during the course of the trial, a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. As you can see, reasonable doubt is the very highest level in our court system. That's down here. What the sergeant talked about, probable cause, that's to arrest somebody. And that is many steps down from where we are now. You might remember the sergeant testifying that if he had known about the other TPO, he wasn't even sure he would have probable cause to arrest. He said there wasn't patience, there wasn't enough time to do that. But if he had, he would not have even had that lower level of proof. Grave suspicion is not sufficient. So if you are back there deliberating and you think, it's awfully suspicious, maybe you should have known, the judge is going to tell you that you would not be authorized to convict Mr. Bryant on that. Instead, the state has to exclude all reasonable theories of innocence to prove his guilt beyond a reasonable doubt. Easier when I'm closer. Okay. This is a jury charge that the state is likely going to harp on very much. And that is, as you have already picked up on, count 2 is a battery count. And the only person who told you anything about it or testified anything about it is Elizabeth. The testimony of a single witness is sufficient to establish the fact. It does not mean you just go with it just because somebody says it. That is not what this jury charge is about. It is sufficient to establish a fact, provided you find the witness's testimony sufficient. You don't have to accept it just because she said it. She is the only one who said it, but there were many people on the scene. And the state brought you none of them. Well, actually, they did bring you Miss Thomas, who said she didn't see anything. So one witness for that situation with the daughter. And you are the determiner of the credibility of witnesses. Obviously, you heard that there's a divorce happening currently, like a current case with upcoming court appearances. You have to ask yourself what interest Ms. Thomas has in the outcome of this case, this criminal case, and the bias that she clearly demonstrated on the stand, whether that affects her testimony, her truthfulness when she testified to you. Prior difficulties were allowed to be heard by you in this trial. Why? The judge is going to give a limiting instruction, but why? Why was 2015 talked about? Why was 2020 talked about before this, in the TPO and this was even sought out? It's because their case is a mess, is why. And they wanted to make Mr. Bryant look bad. He's not charged with anything in 2015. He's not charged with anything in 2020. So you do what you're allowed to do with that evidence, which is consider it for the limited purpose. But you have to ask yourself why. And they didn't bring any additional witnesses to do it. They didn't rely for all of that on just Ms. Thomas. Thank you so much. They didn't have enough to prove this case. So they tried to prove other cases, but still through the same way. You cannot presume that Mr. Bryant was acting with intent. Intent must be proven by the state beyond a reasonable doubt, and that is huge. It is an essential element of both of these counts that he intended. This is count 1. In violation of a protective order, contacts another person at any place other than his own residence. You heard he was on the mortgage. Without the person's consent. For the purposes of harassing and intimidating. To convict Mr. Bryant of aggravated stalking, you would have to find beyond a reasonable doubt that he showed up to that house for the purposes of harassing and intimidating Ms. Thomas. Not for any other reason would he go to this home that he owns. But you would have to find that it was strictly and only exclusively for the purposes of harassing and intimidating. So the court's going to define harassing and intimidating for me. You've heard all of the evidence. This is all that there was in this trial. And the state, with what they showed you, you have to be convinced beyond a reasonable doubt that they showed you a knowing and intentional pattern of behavior. They brought you one incident of them going to the house. And then something from 2015 and then the 2020. That's not a pattern. That's not a knowing and intentional pattern of behavior. It just is not. It's got to be directed at a person to cause emotional distress by placing that person in reasonable fear for her safety. So let's talk about that. The state asked many different ways on their directive, Ms. Thomas. Why did you call 911? Because I wanted him to leave. Why did you want the police involved? I wanted him to leave. How did you feel? I wanted him to leave. We took a break, a 10-minute break. And when we came back, lo and behold, she came back on the stand and said, I was scared. I was fearful. I felt threatened. That's what she said after the break. But before the break, all she said was, I wanted him to leave. It's another credibility of witnesses issue. How that language could all of a sudden start appearing. Here we go with intent again. Simple battery, count 2. Intentionally makes physical contact of an insulting or provoking nature, or intentionally causes physical harm. That is an element of this count. And the state must prove intent beyond a reasonable doubt based on the evidence that they presented to you. That's not enough. Court's gonna advise you that you can't base your verdict on sympathy. If you, Ms. Thomas came in here, and certainly some people could find her sympathetic, but that has no place in how you should come to your verdict. It's not allowed. The judge is going to instruct you that ultimately your verdict has to be unanimous on each count. And that's true. But you don't have to agree on why you find Mr. Bryant not guilty. Somebody could find the surface issue, the due process issue of Mr. Bryant not being served with the TPO. That he's accused in a criminal case of violating. That could be a reason for doubt. Why didn't the state enter Mr. Bryant's TPO that he took out? Why didn't they? I brought it. I talked about it. But that could be a reason to doubt the state's case. The sergeant talked about this CAD report that shows who made 911 calls and when. It's not in evidence. That could be a reason to doubt the state's case. Going back to the notice issue of whether Mr. Bryant actually knew that the TPO was still active, Ms. Thomas took the stand and told you that he was still getting mail at the house he was not allowed to be at. And she confirmed not just junk mail, I don't know, he should have changed his address. But if she is the one providing the contact information, why wouldn't you provide the address he can't go to? The state, Ms. Thomas also testified uncorroborated, this is all just what she said, that at some point in time, Mr. Bryant attended a hearing about something related to this. You also heard that there were divorce filings or whatever. The state is probably going to attempt to argue that she was saying that Mr. Bryant was there in June of 2020 when the TPO was extended. That is almost no evidence of that, because it could be other hearings. She testified to the wrong date of the birthday party to start with. The state had to clean that up. She didn't even have the year correctly. So I would submit to you that that is not evidence of notice or that he knew about this extension of his TPO. Because you heard about how he behaved when he did know about TPO, right? He got the police to accompany him. So if he knew how to behave, but he didn't know. That is a reason to doubt. Another reason is that there are loads of other reasons to go to your piece of property that doesn't have anything to do with harassing and intimidating. And further, once you get there, his behavior was not harassing and intimidating. As she testified to over and over, she just wanted him to leave. So his purpose going over there was not to harass and intimidate, and when he got there, he did not harass and intimidate. You heard that 911 call, and who was mad? You saw that body cam. So going back to the burden word, if you're back there and you're discussing the elements of all of these crimes, these two crimes, all the elements of them, and you think maybe he got noted, maybe he knew he wasn't supposed to be there, maybe he knew that that TPO was extended past when he knew about it. That is way below beyond a reasonable doubt. If you go back there and you think he probably knew, which I don't think the evidence supports, but if you think that probably he knew somehow about this extension, that is still way below beyond a reasonable doubt. So if you find yourself back there thinking maybe, possibly, probably he knew, I don't think it supports that, but you saw the evidence and heard it. But even if you get to probably, you have a duty to quit. And as we already talked about, the state must disprove all reasonable theories except the guilt of Mr. Bryant. All reasonable theories, and there are plenty. I was not anticipating the PowerPoint issue, and I know you have seen me checking my notes. And I'm gonna be honest, it's because I am scared. I'm worried that I haven't done enough to help you see what happened here. That I haven't done enough to help you break down the truth of what really happened. Things are not always as they seem. But I trust that you heard and evaluated the state's evidence, and more importantly, the lack thereof. And I trust that you will apply the law that the judge gives you to that evidence that you heard. And when you do that, this final jury charge, if your minds are wavering, unsettled, or unsatisfied, which they very well should be, that is a doubt of the law. And you must acquit Mr. Bryant. If you have any unanswered questions, if you're back there thinking, man, I wish there was another video, another angle, or if we knew when he knew what and when the TPO was extended and whether he knew, look no further. than the state's table. They have the burden of proof to prove to you beyond a reasonable doubt. So if you have unanswered questions about what happened, feel like you need more evidence, you feel if you go back there and you feel like you need more evidence, that is reasonable doubt. And I believe that you will apply the law that the judge gives you to the evidence as you heard it the past couple of days. You took an oath to do it. You were selected because we knew you could. I'm trusting that you will. As the judge told you, the state gets the final word. As soon as I sit down next to Mr. Bryant, I'm going to think of so many things that I should have highlighted. So many things that I should have pointed out or made a bigger deal of to make sure that you understand it or picked up on it. I'm sorry. And I'm not going to get that chance. I'm going to sit over there and I'm done. That's why it is so important, and I've seen you taking notes. We appreciate your questions and that you really listened to the evidence in this case and lack thereof, and that you're going to use your common sense and reason back there. And you're not going to let the state make you forget what the evidence was and what it wasn't. So now I'm going to give Mr. Bryant to you and ask that you find him not guilty on both counts. Thank you.
Thank you, Ms. Feely. Mr. Whitenauer, when you are ready.
Same here. We come to the end for State versus Stuart Bryant. At the beginning, we had opening statements, and the defense said that looking back, he might have made a different decision, talking about the defendant. But he didn't make a different decision. He did what he did that day, April 30th, 2021. Now he should be held accountable for that. And maybe he could have made a different decision, but he didn't, because he's a bully, and you're here to decide if he's guilty of aggravated stalking and battery. Let's talk about the chronology a little bit. This all starts back in March 2020, when Ms. Thomas received, that is, she was granted an ex parte TPO with the hearing date of March 23rd, 2020. And you saw earlier, when Sergeant Broussard was testifying, that the hearing date was continued several times. March 19th, there's a continuance. And finally, we get to June 19th, 2020, when the hearing was held, and that's going to be State's Exhibit 6. But you'll have back with you that states exactly that. This is a certified copy from the Fulton County Clerk's Office, an order issued by Judge Manning on June 19, 2020. And that judge wrote that a hearing was held and that the defendant appeared and or had the opportunity to be heard. And it was from June of 2020 through June of 2021. And then we get to a date that falls well within that date range, April 30th of 2021. And the defendant, a bully, attended his own son's birthday party. But he wasn't there for cake and he wasn't there for ice cream. He was there to harass and intimidate Ms. Thomas, as he has over the last 18 years of their marriage. what she testified to. And she was so concerned about her continued safety or fear for her safety that she then went and got an extension of that order, and that's in State's Exhibit 7. And you'll be able to go take that too. And in this order from July 22nd, 2021, again, a hearing was held and he appeared and or had the opportunity to be heard. And this was issued so that she can have protection from him through 2024. So there are those other days for continuances. All right, so you heard from 4 witnesses from the state. I'm gonna try to go through their testimony as briefly as I can. Well, we heard from Elizabeth Bryant. She was right here at the stand. She's a nice young lady, flew in from Tennessee before her homecoming weekend. She's gonna be in the marching band to be here to testify and tell you what happened on that day in April. She talks about how her mom's Malika, her dad is Stuart Bryant, got siblings, Bryce, he was having a birthday party that day, and Olivia. She reviewed the indictment and said, yeah, Elizabeth Stewart, that's not my name, but that's who they're talking about, Elizabeth Bryant. You're gonna get a jury instruction about a scrivener's error. And that's what that was, the scrivener's error. That count was talking about Elizabeth Bryant. She identified herself as that person. She testified that, yeah, on April 30th, 2021, I was at home, my mom's home, 3286 Sir Henry Street in East Point, which is located in Fulton County. We had a lot of witnesses talk about, was that in Fulton County? Why? Because we have to prove venue. Something we have to prove, and it was proved again and again and again. She talked about who was there, mother's side of the family, mom, sister, brothers, cousins, what you would expect for a birthday party for a 12-year-old. She was 16 at the time. Bouncy house in the backyard, I think it was a game truck out front, barbecue, and of course that cooler, his cooler, he wanted everyone to know it was his cooler, full of juice boxes and water bottles. Father walked in, party changed. He's yelling, telling everyone to get the fuck out of his house. Called his own daughter, 16 years old, ghetto, bitches, and whores. Took issue with the weave that she had in her hair, saying it was ghetto, and that her nail extensions were ghetto. And he didn't like them so much that he ripped one of those nail extensions off her thumb. And you'll have the photos from that day that were entered into evidence as State's Exhibit 2, 3, and 4. And you'll be able to see on her hand that nail extension's gone. I'll remind you that testimony of her that this defendant assaulted her that day during this birthday party is unrebutted, uncontested, unchallenged. There's no evidence at all that she wasn't assaulted that day. If you believe her.
Judge, I have to object. I'm sorry.
That's okay. What's your objection?
Burden shifting.
To which, I'm sorry, which part of what Mr. Whitenauer said, so I can address it if necessary. I don't want to repeat back what I heard because I'm not commenting on the argument.
That there's no evidence at all that she was not assaulted.
Okay. So ladies and gentlemen, as I've told you several times, and we'll tell you only one more time, the burden, when I give you the charge, so one more time after this, the burden of proof is on the state. The defense has no burden, but the defense has the ability and opportunity to call witnesses if they want to present evidence. You'll be the ultimate judges of what was presented and what wasn't. The lawyers are free to comment on their understanding of what the evidence shows as well. And I will allow Mr. Whitenauer to continue.
Thank you, Judge. I was glad that 88 Green is the one who was able to do the direct of Ms. Bryant, because frankly, I wouldn't understand that process of getting nail extensions. And I wanted to understand about how you get it done 2 days before that they are locked on and it's gonna hurt and it's gonna feel like it's peeling off your fingernail. And so I'm glad that 88 Green was able to do that. And she talked about how there's a cooler in the house. And remember, that's his cooler, a cooler he's upset about being used for his own son's birthday party. And they've taken drinks out, calling us stupid. And she's trying to save what she can. Picking up those juice boxes, picking up those water bottles and putting them back in. And he didn't like it. So what's a bully do? Well, you grab your 16-year-old daughter by the shoulders and you slam her onto the ground. And you make her head hit the hardwood floor. And she told you, it hurt. Well, of course, it hurt. He was frustrated and he did that and he hurt his own daughter. Now, you get to decide the credibility of the witnesses. You get to decide if when she was up here and she was crying and couldn't go on, if that was just all an act. If she, after April 30th, 2021, decided, man, on that day she decided, I want to be part of this scheme to get my dad in trouble. I'm going to tell the officers a lie to get my dad in trouble. And then I'm going to fly back down from Tennessee to come testify and perjure myself just because I want to get my dad in trouble. What does she gain? Is there any evidence that she gains anything from doing that other than the embarrassment of having to admit that her dad assaulted her on that day? What's her gain? You heard 911 calls. There were 3, but I'll highlight 2 here. And one of them, you hear her saying that my father's being abusive. Well, I think that's clear. And he just broke this restraining order against my mom. Please hurry. Please stay on the phone. I don't know what to do. Get out. Nobody wants you around. Well, of course not. He didn't come there to celebrate a birthday party. He came there to harass and intimidate. He came there with a knife, but he didn't help cut the cake or serve the ice cream or tell his son Bryce happy birthday. He just asked him, where's my Xbox? He didn't come there to celebrate a birthday party. He came there to harass and intimidate Ms. Thomas and, as an added bonus, I guess, assault his own child. The 911 call, the second one, Elizabeth is now crying. Please, please come. He just hit me. Please hurry up. Can you stay on the phone? And she explained to you why she wanted them to stay on the phone. Because she was scared, and of course. She's saying, so sad, my brother's birthday party is ruined. And it was sad, but it's good that they were resumed after he was arrested and taken away. And I'd also note that this kind of emotion, this kind of fear that you heard in the calls, you could see in the body cam when the officers arrived. Do you remember when there was a kind of close-up standing Miss Bryant? You could see her hand shaking. So is that an act? Shaking her hand? I think not. Let's talk about Miss Thomas. Talked about the birthday party just like Miss Bryant did. You got the game truck. You got 25 kids, about 7 to 8 adults. And it was good. It was a good party. Bryce was having fun, as you would expect. But that fun disappeared. All the joy went out of the air as soon as that man arrived at 3286. His demeanor was described as angry and aggressive. He was using a loud, rude tone. And Ms. Thomas testified that she saw him go upstairs into the bedroom and then to Bryce's room. And the first words to Bryce, the 12-year-old, is, "You took the Xbox out of my room." Clearly not there for any other purpose but to harass, intimidate. Not just Ms. Thomas, but Bryce's own son and Elizabeth, his own daughter. Ms. Thomas testified, and again, this is unrebutted, uncontested, unchallenged testimony, that Mr. Bryant got in her face, nose to nose, and told his wife of 18 years, "You fat bitch, you're going to jail, you're destroying my house." Of course, there's no evidence that any destruction of the house was going on that day, only that they were celebrating a 12-year-old's birthday party. He was threatening, aggressive, loud, typical behavior. And we heard about some of that typical behavior when she talked about some of the prior difficulties she's had at the hands of Mr. Bryant. So it was about 35 minutes, 40 minutes from the time he arrived until finally officers came and determined that yes, there is a valid TPO and no, you can't be here, and removed him from the property, arrested him. She reported the officers what happened, showed that TPO to the officers, which is going to be again, State's Exhibit 6. And eventually, Mr. Bryant was arrested. So there's a couple of pulls from that TPO, and it was read to a few times, but I can't stress enough that he was at the hearing. He appeared and/or had the opportunity to be heard. And there's a lot of focus from the defense about, well, what about service? What about service? What about notice? Right? They tendered in some exhibits here, Defense Exhibit 1, saying there's no service, and Defense Exhibit 2 saying there's no service. And well, unfortunately, There's not a requirement in the law, and the judge will instruct you on this, that there be some proof of service. That's not one of the elements of aggravated stalking. In fact, you're going to get an instruction that there's presumed notice if there is a written order. You're going to get that law. And so I think that will clear up some of the questions that you'll had earlier about that issue. But that order was in effect from June 2020 until June of 2021, and April 30th, 2021 falls right in there. And the petitioner, Ms. Bryant, had the sole and exclusive possession of that residence on that day. And it was the respondent, the defendant, who was restrained and enjoined from approaching within 200 yards of the petitioner and or the petitioner's minor children. Now, you can see it on the body cam yourself, but Mr. Bryant was clearly within 200 yards on that day. He was standing right next to her and just a few feet away from Ms. Bryant. He's clearly in violation of the order. Sergeant Broussard said, yes, absolutely. 3 feet is less than 200 yards. Let's get back to Ms. Thomas. So she did have an opportunity to talk about some prior difficulties between her and Mr. Bryant. And it's been admitted to prove motive and intent that he went there that day to harass and intimidate, to not attend that birthday party, and not, as was suggested in opening, which is not evidence, that he was there to retake his house or to inspect for property damage. That's not an evidence. But what is an evidence and what is unrebutted, uncontested, and unchallenged is that in 2015, they were in a different house. And that there was an argument, as was typical. And during that argument, Mr. Bryant pushed her to the ground and he began to kick her. And that assault screwed up, her words, my ankle, that she couldn't walk. And that while she was a bartender having to be on her feet, she had to bandage it and work through the pain. And she told you, she was embarrassed that she didn't report all these things. And that now, only now she's coming out, that she said she was relieved that now she's done it. And of course, there's gotta be some comfort in knowing finally you're speaking up for yourself and you're holding him accountable. February 2020, in the bedroom, minding her business, wanting some privacy, door locked, and here comes Mr. Bryant busting through that door, just as he did on April 30th, 2021, uninvited to that birthday party and not supposed to be there. She's talking on the phone. He proceeds to kick the door in, take the phone. She's trying to call the cops. And of course she can't because he takes the phone, slaps her, calls her a whore, and says, it was always hitting me in the face. It's just another day. And finally, March 2020, she's trying to go to work. She had her hair braided. That's all she wanted to do. And this man, a stronger, taller, and a stronger and taller person prevents her from doing that. Remember her testimony, he was boxing me in, he's keeping me in that corner. And that's what he was doing that day, but that's what he's done in this relationship. He's been trying to box her in, to keep her in. And when she came to testify, she was able to get out. When she came to testify and tell you about this pattern of harassment and intimidation, she finally was able to get out because she put in your hands the ability to hold this man accountable for what he's done and what he did on April 30th, 2021, which was to continue that pattern of harassment and intimidation. Officer Clairville, I'll be honest with you, he was nervous. It was his first time testifying. And so some of his answers were a little short, some of his answers might not have been as robust as you might have liked, but he testified that he arrived on scene and he was trying to get statements from Ms. Thomas, but he couldn't because Mr. Bryant was interrupting. And you saw in the body cam video from Sergeant Broussard's perspective twice, sir, over there. Comes back, sir, you gotta go over there. Second time we figured it out, let him talk. Said that Mr. Bryant had actually become aggressive, that they had to get him to separate from the parties, Ms. Thomas and Ms. Bryant. He initially was handed that TPO from Ms. Thomas, again, stayed sit. And then when Sergeant Broussard arrived on scene, he kind of took over. He has quite a bit of experience from his 20 years in TPO service process and just reviewing them. And eventually, Sergeant Broussard does come on scene. He takes that, we saw the video, his clinking handcuffs and keys, walking to the scene, walking back, gets onto his GCIC terminal and is able to determine that this was served and was active on April 30th, 2021. Again, that testimony was unrebutted, unchallenged, uncontested. And he took his time, and I think we have to appreciate that. He wanted to make sure he was doing what was right. He took the time to read it once while he was there in the law, and then after he went to his terminal in his car, you saw him there on the hood again, going through it, and also making sure he would observe the parties. Less than 200 yards. Yep, it is. Okay, this is a proper arrest. It's time to effectuate it for aggravated stalking and battery. And we also asked him, well, would you ever have been able to arrest Ms. Thomas that day? Because the ex parte order, TPO order, hadn't been served. And in fact, we have that in evidence that it wasn't served. He said, no, I couldn't. You've got to have it served, the ex parte TPO order, in order for it to be uploaded onto GCIC, for it to then be active, and it wasn't. And so there's no probable cause for him to arrest Ms. Thomas. So those are our witnesses. That's our evidence, and you'll have these documents back with you. The body cam and the 911 DVDs, those will go back with you. If you want to listen to them or watch them again, you just got to send the judge a note. Or maybe not, I don't know. They're looking at me oddly.
You do, I'm gonna tell you that. Just looking, I'll look the other way.
All right. So that's our evidence, and you can take that back with you. And I want you to take your time and review it. But let's talk a little bit about the law. Your duty is pretty simple. It's that you've got to follow the law, and you've got to be a fair and impartial juror. You've got to honestly be seeking the truth, and you're not to seek doubt. You're not supposed to look over here and be like, man, what can we figure out, like something that maybe there was this, or maybe there was that thing. You're not supposed to try to look for doubt. You're supposed to be, you're here to find the truth. That's what you're here to do. So stay in the lane and find the truth in this case. And you're bound by the instructions in the law given to you by the judge, and that's going to come right after I said. And again, you're going to hear that important piece of the law that there's presumptive notice if there's that written order. Here it is. So here's some things that you are to consider, some things that you are not. So, everything in the circle, A-okay. But everything out, no. No passion, can't rely on public opinion, that you're unhappy with the police, that there's some public feeling about issues like this, any sympathy you might have for the defendant, any prejudice you might have, that's out, that you might disagree with the law, or that you have some concern about potential penalties or punishment. All that, you got to push outside of your mind. You got to stay focused on what's been admitted as evidence from this witness stand, or in the form of these documents, or the videos, or the 911 calls, statements. I'll go back. There was no expert testimony, but we do have testimony of two victims, Ms. Thomas and Ms. Bryant. We have photos, we have documents, and you have your common sense. And using that common sense, you get to consider the testimony of the witnesses, and you get to think about, do they have any motive to lie? What's Ms. Bryant's motive to lie? Well, we didn't hear any. She's not making any money coming down here. She's certainly not having fun when she's away from school and homecoming band. What's Ms. Thomas's motive to lie? Well, there was mention of the divorce. Well, there's no evidence that by her testifying here, her divorce gets better. That's just speculation from the defense. There's no evidence that she's got a book deal because she came in to testify to you. There's no evidence that she's making money because of this. There's no evidence that she feels great coming in front of you and testifying about how Mr. Bryant has abused her in 2015, in February 2020, in March of 2020, in April of 2021. She gets nothing from that except embarrassment and shame. But at the end, a little bit of happiness knowing that finally she got to tell you her story. She did get that. You have to consider the elements of the crime. We'll talk about those in a minute. All right, you got to do deliberate. You got to go back there and deliberate. You got to think about the evidence, think about what you saw and heard, and you got to talk about it. You have that duty. And if a juror refuses to deliberate, refuses that duty, you should bring that to the attention of the judge by way of a note. And we all know how to write notes, so that shouldn't be a problem. All right, let's talk a little bit about the legal principles. Burden of proof. I think we know what it is by now, but I'll say it again. It's beyond a reasonable doubt. It rests with the state, and we're okay with that because we met our burden in this case. What is reasonable doubt? Well, it means just what it says. It is reasonable. It's based upon your common sense. It does not mean a vague or arbitrary doubt. It's a doubt for which you can give a reason. And we're not required to prove the guilt, not guilty, of the accused beyond all doubt for mathematical certainty. A reasonable doubt is a doubt of a fair-minded, impartial juror. That's what we're asking about during voir dire. Honestly seeking the truth. Again, you're not to seek doubt. What about this? Maybe that. No, you're here to seek the truth. Presumption of innocence, also important. The defendant is presumed innocent until proven guilty beyond a reasonable doubt. But when the state rested, that presumption of innocence was gone. The defendant was then guilty because we put up all the evidence that you needed to find that we met all the elements of the 2 counts in that indictment. With each piece of evidence that came in, that presumption of evidence went down. So you're able to say, he's guilty of these offenses beyond a reasonable doubt. Ms. Bryant testifying, he assaulted her. The photos of her injuries. Her motion on the stand having to talk about it. The TPO order. And the fact that you can see Mr. Bryant on the body cam that day at a place where he was not supposed to be, and at a distance he was prohibited from being. Attorney's questions, all the questions that I asked, all the questions that they asked, not evidence, but the things that you heard from the stand, evidence. All right, direct and circumstantial. Most of the evidence that you heard in this case is direct. You've got these photos, you've got the testimony, you've got these certified documents right here. But let's talk about how they're different. So you can consider both. Direct and circumstantial are both great. And direct is just that it points immediately to the question at issue. Circumstantial are facts and circumstances from which you may infer from other related or connected facts that are reasonable and justified in light of your experience. So let's talk a little bit about what direct evidence would be in this case. Well, it's evidence that points immediately to the question at issue. So testimony from witnesses, what they saw, what they heard, what they felt. An example would be if you had some DNA evidence or some of these photos. Circumstantial evidence would be proof of facts or circumstances by direct evidence from which you can infer other related or connected facts that are reasonable and justified in light of your own experience. So here's kind of the circumstantial evidence. So that phone up is taking the gas. So we never see the gas go in, but how do we know it got there? Well, you're able to start your car, right? It keeps running. So just because you didn't see it go in, you know that it had to have gone in because you heard it going in maybe, and also you're able to start the car and you see that little dial go up on your dash. But again, I think we'll focus more here on direct evidence. So let's talk a little bit about those elements for aggravated stalking. That's the first count in the indictment. Judge didn't talk to you about this. He's going to tell you what they are, but a little preview. You got to have contact with the alleged victim. Well, the alleged victim here is Ms. Thomas. And I don't think there's any question that on April 30th, 2021, Mr. Bryant had contact with her, clearly within 200 yards, somewhere other than the defendant's residence. Well, per this order, that residence at 3286 on that day, April 30th, 2021, was in the sole and exclusive possession of Ms. Thomas, not Mr. Bryant. And it was without the victim's consent. Ms. Thomas, did you invite him there? No. Did anyone else invite him there? No. Did you want him there? No. He was there without her consent. And it wasn't for that birthday party. You didn't hear any evidence about him being there to cut the cake, to bring a present. Well, he definitely didn't bring a present. We didn't see it on him. He was there to harass and intimidate Ms. Thomas, as he has for that 18-year marriage. And it's got to be in violation of the temporary protective order prohibiting such contact. And this temporary 12-month protective order prohibits that contact. And it's part of a pattern of harassing and intimidating behavior. And there is that pattern. And they say, well, that's 2015. I mean, that's so long ago. Well, let's think about the context. An 18-year marriage, 2015, February of 2020, March of 2020, and then in April 30th, 2021. There's no requirement in the law that the pattern be like, oh, it was Monday and Tuesday and Wednesday. You can have a pattern over many years, and over an 18-year marriage, it's not unreasonable that there be incidents back to 2015. That is a pattern of regular abuse by Mr. Bryant against Ms. Thomas. And also, I note, it doesn't have to be that he violates this TPO in a pattern, that he comes back again and again and again during this period. There's no requirement in the law of that. It can be a pattern that's established before and then at least one time in violation of this order. And that's what we have here. So this is what I kind of mentioned a little bit earlier. This is, I think, going to clear up a lot of the questions that you have in your comments about, and the questions that the defense wants you to focus on about service, notice. This is what you're going to hear. The state is not required to prove that the defendant received actual notice of the temporary protective order if the state proves that there exists a written court order restricting contact by the defendant with the victim. And that's what we have in state 6. And you also know that you're not going to see anywhere in the law that the judge gives you that there's an element of notice. But even though it's not required, you know that he either attended it or he had the opportunity to be heard, and it was entered. And you have testimony from Ms. Thomas saying, yeah, he was there too. He got notice of the order that day was issued from the court that issued it. That's due process. Civil battery is a little bit more straightforward. Person commits the offense of simple battery when that person either intentionally makes physical contact of an insulting or provoking nature with the person of another, or intentionally causing physical harm to another. In this case, we're going forward on insulting and provoking. And I think we can all agree that when your dad grabs you by the shoulders and slams you to the ground during your little brother's birthday party, that is insulting and provoking. And there's no requirement for the way it's charged in this count that would prove some physical injury, some substantial physical injury. Like she told you, one, it had hurt, and two, that yeah, it hurt when he ripped off my fingernail. That was insulting, that was provoking, that was terrible. All right, you heard a lot about venue. We would ask what did happen in Fulton County. I don't think there's really a question that it did not happen in Fulton County. The location 3286 or Henry Street, East Point. All of our witnesses said that's in Fulton County. Identification, I don't think that's really an issue either. Numerous witnesses, Ms. Harris, Ms. Bryant, the officers who testified, all said, yeah, that's the guy right there. He did it. So you get to decide which witnesses to believe. You have to decide and consider the manner in which they were testifying, the interest or lack of interest in this case, and the opportunity for knowing the facts to which they testified. So thinking about Ms. Bryant, how did she testify? Was she happy to be here? Is this a great experience for her? What gain, what interest does she have to testify that her dad assaulted her? What did she get out of that? And the opportunity for knowing the facts to which she testified. Well, she was there. We saw her on body cam. She was there that day. And so she has firsthand knowledge that that happened. And of course, personal credibility. I think they had credibility in taking the stand, and they had courage in taking the stand, and telling you about what happened that day. And the courage and the strength to get out from under Mr. Bryant. Testimony of a single witness. And yeah, that's right. The defense is right. The testimony of a single witness they believe is sufficient to establish a fact. I don't think you've heard any testimony or received any evidence that would lead you to say, I can't believe Ms. Bryant, I can't believe Ms. Hawkins. So there they were, Ms. Bryant, Ms. Thomas, officer, sergeant. And all that testimony from Ms. Bryant, that was unrebutted. When she testified that he grabbed me and he slammed me, unrebutted. That my nail extension got ripped off, unrebutted. What's to be gained? We've already talked about that. Ms. Thomas, unrebutted. We got the valid 12-month TPO. Defendant comes within 200 yards. He's not there for that birthday party. He's not retaking the house or doing a damage assessment. That's not in evidence. You didn't hear any of that. That's what was said in opening statements. And he wasn't there for birthday cake, even though he had that knife. And he wasn't there for that water slide or that game truck. He came in there to show up and show out. We heard about prior difficulties in 2015, February, and March 2020, over that course of that 18-year marriage. All of that unrebutted, uncontested, unchallenged. And then you heard that unrebutted testimony from Sergeant Broussard. When I asked him, what's the controlling order, unserved, ex parte TPO over this right here, the 12-month temporary protective order, in which there was a hearing. I said, yeah, that's it. I didn't have any reason to arrest Ms. Thomas that day. It was Mr. Bryant all day long. But, we got some distractions from the defense because that's their job. And that's okay. Talking about where's the service? Well, the law will tell you about that. Service is not an element of the offense of aggravated assault. In opening, we talked about 3 children, like that was some excuse for assaulting Ms. Bryant, one of your children, or from violating a TPO. And that it was during the pandemic. Well, we all made it through the pandemic without assaulting our child or violating a TPO. And it was his cooler. Okay, so what? And then there's questions about, what about the defendant's ex parte TPO? Well, it's not in evidence because Ms. Thomas is on trial. Mr. Bryant is on trial. And so we put into evidence that would show that Mr. Bryant violated this TPO and committed the offense of aggravated stalking. And the law is clear. The existence of this written order is presumptive evidence of notice to the defendant. And none of their concerns and their distractions change the fact that Ms. Thomas's TPO, this one that we have here, was served, First Sergeant Broussard, was active on April 30th of 2021. Excuse the error. And, if Mr. Bryant really was concerned about following the law, he would have arrived with law enforcement that day, but he didn't. He rolled up by himself, ready to make a scene, and he succeeded at doing that well. And so we're not here to prove that Ms. Thomas violated the TPO. She didn't. She couldn't, because it wasn't served that initial ex parte TPO. So once you go back and you review all of this evidence, this TPO, these photos, the body camera footage, the 911 calls, and the unrebutted, uncontested, unchallenged testimony of all 4 of the state's witnesses, I hope they come to the conclusion, the right conclusion and the truth, which is that on April 30th, 2021, Mr. Bryant went over to that address, violated that TPO, and assaulted his daughter, and they hold him accountable for that, and find him guilty of aggravated stalking, find him guilty of battery. He already knows he is. Just tell him.
Thank you, Mr. Whitenauer. If you all could stop the screen share.
Done.
Excellent. So we've been going for about an hour. I need to share with you all some law. It is not as interesting as what the lawyers just shared with you. I will have a PowerPoint, but it's just words. So if you all think you need a quick break, we can do that. If not, at least everyone stand up and shift around a little bit so that you're focused for the law that I'm going to give you. And Ms. Evans, if you don't mind, since you're the closest, there's one for the state and one for the defense. Thank you so much. All right, well, you're all seated, so I'm going to view that as a sign to get rolling. Ladies and gentlemen, in a moment, I'm going to share with you the law, we call it the jury charge, that you must apply to the facts as you find the facts to be. This will be delivered to you orally. I will be reading it to you, so a record is made, but it'll also be on a screen. So hopefully both those screens will show in a moment the text of what I'm reading to you. And more importantly, for those of you who've been trying to keep up by taking notes, this jury charge from which I'm reading we'll go back with you during your deliberations. So feel free to write things down. But if something goes by too quickly or it's kind of confusing, it may remain confusing, but you'll have this document to read as many times as you want during your deliberations. Before I dive into this, I do want to let you know that there are certain legal concepts that I am required by higher courts to describe in a particular way. So my goal in preparing this document is to make it accessible to you and to me and anyone else who might need to follow along with what the law is supposed to be. But there are some legal concepts that have been formally defined by the higher courts in a way that may seem to you a bit stilted, and I apologize in advance for that. It's not me trying to talk down to anyone. It's a higher court saying, here's how you have to say these certain things. They're in here, but where I am able, I try to make the charge as accessible as possible. So let's see if I can get this working. There we are. All right. A grand jury has indicted the defendant for aggravated stalking and simple battery. And they've done so in the form of this indictment, which you will also have for you during your deliberations. It's okay that you yawned. The defendant has entered a plea of not guilty to these charges. And the indictment and the plea of not guilty, which is indicated by the defendant's signature here, form the issue that you are to decide. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent until proven guilty. This presumption remains with the defendant unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or both of the crimes charged. The state bears the burden of proving beyond a reasonable doubt every material allegation in this indictment and every essential element of each crime charge. And I'll tell you what those elements are a little bit later. There's no burden of proof upon the defendant, and the burden never shifts to him to introduce evidence or prove anything. If a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. That reason that arises from a consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all that evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant a grave suspicion of the crimes charged, or that merely raises a speculation or conjecture of a defendant's guilt, is not sufficient to authorize a conviction. It's my responsibility to determine the law that applies to this case and to instruct you on that law, which is what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts of the case from the evidence presented. Then you must apply the law, as I am giving you, to the facts that you find. You must decide this case based only on the evidence presented here in court. That's that admonition of no outside research. The evidence that you've received consists of all witness testimony and exhibits admitted. Evidence does not include the indictment, the defendant's plea of not guilty, anything that I've said or the lawyers have said, or any questions posed. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. This would be an eyewitness. I saw, I heard, I felt. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. Well, I wasn't there when it happened, but I saw smoke in the distance, and maybe that's evidence of a fire. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided that you find the witness's testimony to be sufficient. You must determine the credibility or the believability of the witnesses who appeared before you in this case. In deciding this, meaning the question of credibility, you may consider all of the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider, where applicable, other evidence offered to attack the credibility of witnesses, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of a witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. Defendants who have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Testimony concerning prior difficulties between the defendant and Ms. Thomas has been admitted solely for the purpose of illustrating, if it does, the state of feeling between the defendant and Ms. Thomas, as well as motive and intent. Whether this testimony illustrates these matters is for you to determine, but you are not to consider that evidence of prior difficulties for any other purpose. The defendant is charged with two crimes, aggravated stalking and simple battery. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime and must be proved by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but means simply the intent to commit the prohibited act, to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, upon a consideration of words, conduct, demeanor, motive, or other circumstances. Knowledge on the part of the defendant that the crime of aggravated stalking was being committed and that the defendant knowingly, intentionally participated in such crime must be proved by the state beyond a reasonable doubt. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the crimes, the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt as to each crime charged. Here are the elements for aggravated stalking. For aggravated stalking, the state must prove that the defendant, number one, contacted the alleged victim, two, somewhere other than the defendant's residence, three, without the victim's consent, four, for the purpose of harassing and intimidating the victim, and five, in violation of a temporary protective order prohibiting such conduct, meaning such contact. Contact includes, but is not limited to, communication in person. Harassing and intimidating, as that phrase is used in this instruction, means a knowing and intentional pattern of behavior directed at a person, which causes that person emotional distress by placing her in reasonable fear for her safety or the safety of her immediate family, in which serves no legitimate purpose. The state is not required to prove that the defendant received actual notice of the temporary protective order if the state proves that there exists a written court order restricting contact by the defendant with the victim that was in force at the time the contact allegedly occurred. The defendant does not have to threaten serious bodily harm or death for the contact to be harassing and intimidating. The other charge in the indictment is simple battery. A person commits simple battery when he either it says 1 on the screen. It says A in your instructions. A and 1 are interchangeable here. Intentionally makes physical contact of an insulting or provoking nature with the person of another, or B, or 2, intentionally causes physical harm to another. Scrivener's error, like A and 1 and B and 2, where a variance exists between the victim's name alleged in the indictment and proven at trial, the variance is not fatal if the two names refer to the same person. Ladies and gentlemen, by nothing I've said, no ruling or comment that I have made during this trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the law that I'm giving you now. It is your duty to consider the evidence objectively without favor, affection, or sympathy to either party. It is also your duty to report to me if you observe a juror making decisions based on improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is the role of the judge. One of the first things you'll do in the jury room, where you will go very shortly, will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case and a careful consideration of the evidence. In the jury room, you will have a verdict form. You should consider each count individually. The defendant may be found guilty of one, both, or neither of the charges. The defendant, if after considering the evidence together with the charge, you should unanimously find beyond a reasonable doubt that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And in the blank on the verdict form for that particular offense or crime, you would write the word guilty. If you do not believe that the defendant is guilty of a particular crime, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And in the blank on the verdict form for that crime, you would write the words not guilty. Whatever your verdict is for a particular count, it must be unanimous, and your verdict must be in writing, signed by your foreperson, and dated. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. I don't lift that prohibition once you start deliberating. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with this instruction, Deputy Gordon will be collecting your electronic devices while you deliberate. We'll give them back, but while you're in the jury room, no phone, no tablet, no Apple Watch, nothing that you could use to talk with folks outside the four corners of your room. And finally, going forward, should you need to communicate with me for any reason, it needs to be in writing. I will, upon receipt of your question or note, confer with the lawyers and share with you whatever response I am allowed by the law to give you. And I qualify that because you may ask what seems like a bang up question, and I have to send back a note saying I can't help you with that. And that is not me being ornery, but you may well ask a question where my response is you have to rely on your recollection. For example, you may send a card out saying, could we please have Ms. Thomas's testimony? I told you at the beginning, you're not getting transcripts of witness testimony. The answer will be you'll have to rely on your recollection. You may, on the other hand, send out a note that says, could we please watch the video or listen to the 911 call again? The answer will be yes. And we'll bring you all back out here and we'll put that call in, press play, put that video in, press play, and you'll be able to handle it that way. And with that, ladies and gentlemen, my instructions to you are complete. And in a moment, I need all of you except for Mr. Robinson and Ms. Freeman to go to the jury room. So Mr. Robinson and Ms. Freeman, stay put. The rest of you go to the jury room and start shedding your electronic devices. Please don't begin your deliberations until we get the verdict form and the evidence, the indictment, and this jury charge back with you. Thank you. All right, you all can be seated. You two are our alternates. You were our safety, and you remain our safety if we lost jurors for family conflict, who knows what. We live in complicated times. Maybe a little piece of Ian broke off and messed with their house. Fortunately, we didn't lose any jurors yet, but the two of you have heard and seen the very same set of evidence as everyone else. What I'm going to ask you to do for the rest of today, as long as the jurors are still here, is to be in the other jury room. You will be free to do work, sleep, nap. You can chat. Don't talk about the case, and no outside research, because if we have to excuse one or two jurors, you'll be pressed into service. They'll need to reset their deliberations because you weren't there for any of them, but you still could serve as a deliberating juror. If the jury does not finish its work today, before you go today, we can talk about being on call. Really just depends on how quickly you could get down here. If the other 12 are coming back at 9 or 10, whenever they want to be here tomorrow, and they'll make that call, you'll either need to be here with them, but in that other room, or commit to being able to be here within about a half hour. And if work is just not the kind of thing you could extract yourself from, then you'll come back with the other jurors. If they finish their work today, after I am able to receive their verdict or whatever their announcement is, and it's official and not rescinded for any reason, we'll bring you in the room as well so you know what happened. We will not forget about you. And we'll make sure that when your colleagues are excused, you get excused as well. So the two of you, please go in the jury room, get your stuff, including your electronics, go with Deputy Gordon. He'll get you set up and we'll take it from there. Thank you. Mr. White, now, are any exceptions to the charge as it was read beyond exceptions you've made before?
No.
Ms. Feely.
I think I do have to renew my objection to the notice portion of the aggravated assault jury charge, or
Yes.
aggravated stalking, I'm sorry.
Yes.
So we would like to renew that on all the grounds as stated before, Fifth Amendment, 14th, and burden shifting.
Sure, and that would be the paragraph in the aggravated stalking charge that's on page 7. It's the first full paragraph about the requirement of proving notice.
Yes.
Okay. That has been renewed and further preserved. I'm going to print out the verdict form, have everyone look at that, and we'll go from there.
Judge, may I start collecting the evidence?
Yes, please, and confer with Ms. Wood to see if there are issues with anything going out.
Yes, Judge.
And I wanted to put one more thing on the record now that they're
They're gone. Yes.
I just wanted to perfect my objection to burden shifting. I didn't want to take up too much time in the state's closing, but I did want to preserve that issue of.
Sure. No. Why don't you do that? And as specific as you can get about what you thought Mr. Whitenauer said that prompted the objection.
Yes, I should have obviously written it down, but my ears perked up because it was like, I was saying that the defense didn't call witnesses to, because I think they were skirting the line saying that things weren't rebutted or and stuff in that line of argument. But then saying that we didn't call witnesses, I think was where I objected at that point.
Okay. The record will reflect what Mr. Whitenauer said. My recollection is that he was talking about that there was no evidence to the contrary. And if it went further than that, I feel like the pause that you had us make, which was appropriate, and what I shared with the jury about who's got what burden addressed that. Thank you. And now the verdict form.
Wait, what'd you say?
Can you confer with the defense attorneys?
Yes.
Thanks.
So I think
Okay.
Right.
We'll go through.
Yeah,
so.
sure, yeah.
Let me get, yeah, let me see this.
State 6 goes back, like where are we drawing the line? Everything's going in? Or-
That would be my position. What is your thought?
The 6 is about like.
It is.
Yeah. Okay, so everything.
That's what I'm saying, yeah.
So right now, if you would look at the verdict
I get it
and
all out of order.
share it with the defense. Thank you.
Sorry.
So the verdict form.
Right.
And that's right on top. All good? All right.
Thank you.
State intends to view the exhibits and we have agreement about them going back.
Okay.
And the verdict form.
All right. So Ms. Wood, you had a chance to look at the verdict form?
Yes, Judge.
No objections?
No objection, Judge.
Okay. Then we'll get Deputy Gordon back in here and he can take that and the and the indictment and jury charge. If I could get, you can write it on one note card, one phone number that will get a lawyer from the DA's office and one phone number that will get Mr. Bryant and a lawyer from his team back in here. You're welcome to stay in the courtroom, but if you stray, I need to get you back here when there are questions.
Judge, do you have a light? Is your light on?
I think so. Deputy Gordon manages that.
Oh.
I'm gonna go back and do some work. So I don't, but I do think that something like that goes on.
Me.
Whoops. It's not the right button. Hopefully he'll be back soon. He's probably fighting over cell phones.
Yeah.
Thank you. Where's 205?
Alabama, Judge.
Alabama.
You have quite the fan base over there now.
Are there any deputies out there? No? Okay. Well, just so we can get going, we got the evidence for the jury. Okay, thank you.
Okay.
There's someone. Excellent. Can you please take that to the jurors? That is evidence, verdict form, indictment, and they are off and running with that. And then there was a question about, we're good. Couldn't find this guy. He was sleeping in the jury room. Yeah. What was weird is there were jurors in there, so that made it even more bizarre. So the lawyers were asking, does that light work? Like when the jurors, so they'll know if they're in here and like, oh, light. Okay. All right, great. Get that to jurors. I'll be back there. And I've got phone numbers for everyone. Thank you.
Sorry. Mine too, because my stomach was growling.
Carolina too.
You have so much candy.
This is a lot of.
Oh, yeah? Yeah, you can move. Whatever you need to.
Are you all going to stay in here? Because I can mute the microphone so that it's not going all over the planet. But if you're not going to be in here, I'll just leave it on.
I'm gonna stay here.
Okay, I'll mute it. They don't need to hear you chewing.
I'll follow the leaders.
All right, we need to get Ms. Rivers out here and then we'll get going. No problem. Jury surprised us with quick questions. You ready? Okay, we're back on the record in State versus Bryant. The jury had two questions. The first reads, do all, which is underlined, 5 elements of aggravated stalking need to be met to be considered proven? Second question in different handwriting. Can we watch both body cam footage again? The answer to both is yes. My thought is to bring the jurors out so they can watch both body cam footage again. And when they're out here before then, I will remind them that the state has the burden of proving beyond a reasonable doubt each and every element of both of the alleged crimes in this case. Does that approach work for the defense?
Yes,
Yes,
Your Honor.
Judge.
Okay, Mr. Whitenauer?
Yes, Judge.
Great. Let's bring the jurors out. Please.
All right, for the jury.
Let's do seats. Let's
Oh, you're the first?
Let's
You still can sit wherever you want, but you do have 2 empty seats. Someone can spread out. All right, you all can be seated. Deputy Gordon delivered me 2 questions. The answer to both is yes, but I'll make it more formal. One of the questions asked whether all 5 elements of aggravated stalking, it says, need to be met to be considered proven. The way I'm going to answer that question is that the state has the burden of proving beyond a reasonable doubt every element of each charged crime. The other question was, can we watch both body cam videos again? And the answer is, of course. And I'll ask Mr. Whitenauer or Ms. Green to engineer that, since you all played it before. And we should be clear about what exhibit numbers. I assume exhibit 8 is Officer Clairvaux, so we should play exhibit 8. And I think exhibit 9 was Sergeant Broussard's. It's 9 or 10, but before you play them, let's make clear which one it is that we're playing.
The first one will be Officer Clairvaux.
Okay, which I think is Exhibit 8.
Yeah.
We'll make it as loud as we can, which it probably was the first time you heard it, unfortunately. I'm gonna authorize, are you all right if we fast forward to actually getting there?
Yeah.
Thanks.
I got paperwork showing that she got served yesterday. I was coming to check my house, and it's COVID, so I'm not gonna get too close.
I'm the mother. I filed a restraining order against
Which
this
ended
man.
in March,
No,
March
no,
3rd.
Bubba.
Hold on, man. Wait. I'm about to show you one that's updated. All right.
June. It says June 18th.
Yeah, but it's been that one was back in March 3rd. It ended March 3rd. This one here is recent. I just filed this one last month, and she should have been removed yesterday. The police came here yesterday. I don't even know why. Did you have a copy of that? Say what? Where is that? I haven't been down there to get it yet. But they sent me this from was it served? Yeah, she got served.
I did
She
not
got
get
served.
served. I was at work. I was
police
not served. I was not served. I was not served.
Well, my thing is, I got a notification that that the police were here yesterday, so I was under the impression because we don't have contact
of Fulton County.
Yeah, I got
you all
Superior
can.
Court
I'm
as well.
gonna keep this one. You all have that.
This is the last time I was out
the
there.
same. No, I had copies made, but these are the same.
In your mind. Jeez.
Hey, come on, man. Thank you.
Over there. Go over there.
Here. Petitioner, which is me, is awarded sole exclusive possession of this residence.
Over there, sir.
Thank you, sir. Until this said date.
And this was served?
Yes, sir.
What happened in the house?
I'm having a birthday party for his son. My son, he hasn't seen his kids in a year, and he comes in, dumps out the ice cooler saying it's his. I got to get out of his house, and I have these documents. I don't have to go anywhere.
But what happened to her?
He smacked me if my nails broke. I just got these done. That's his child. Coming in, cursing us, calling us bitches, telling us to get the fuck out. I got a backyard full of children. It's my brother's birthday party. And
2021.
I remember because he came over here last time to get property.
And I do remember you.
He's taunting my mom. He's saying, like, you just heard he said she has something in her mouth, and I smacked.
And it's my son's birthday. We got the gamer's truck outside for my boy, a water slide in the backyard full of kids.
He doesn't even have a license. I don't know how he got
License,
over here.
right.
I'm gonna take him away. He came
So he had to come here.
27, confirm you at Marketplace Boulevard and
Stuart Bryant. What's his birthday?
October 76.
October 31, 76. Let me check to see if it's on GCIC. If it is, then we'll go.
Can I go back and tend to the children, or do I need to stay out here?
Just stay right here for a little bit.
Sorry, will you do me a favor? That meat, if maybe some empty pans, maybe pull it off. I got some more to go on there. Thank you. Are you pants dry? You gotta get on the bangle. Yeah, you dry.
Are you going to the game here?
Yeah, I'm taking you try it out. Get the
Thank you, Granny.
This body experience.
Thank you, Granny. Oh my God. I look stupid.
Is that your dad?
Yeah. And her dad and my son's dad, he was married, was still currently married. I filed for a divorce. They dismissed it because the cops who did it wrote I had all of that paperwork, worked the case number down, so they dismissed it. So unfortunately, still married, still going through this shit. Excuse my language. It makes no sense, and I can't believe that he is this brazen to come in here and disrupt his own son's 12th birthday. Didn't send him a card, didn't get him shit, ain't did nothing for these children in a year. It's been all on me. And these 3 kids, my son has autism. My daughter was cutting herself because of this man. You know what I mean? I got it. Oh my God.
It's the same paperwork my son got?
Same paperwork. I made several copies. What about it? And from what I'm understanding, when we went to court, he's not allowed to put up a restraining order on me when I have one on him for family violence. I can bring you that whole packet of how he has beaten, how he has bad talked, how he has degraded and demeaned his children. His house is in foreclosure, and you want to come try to put me and these children out, and they're your fees just for the sake of me being homeless? I can take care of mine. You can put us out today. We'll have somewhere to stay.
But he don't have that right.
But absolutely. On the deed. You can't put me out. I'm not on the mortgage, but mine is showing up on that deed. You can't do anything with this property without me. I really cannot believe this.
Okay.
Thank you, bud.
I understand. 19, put your hands behind your back.
Are you through?
Yes. No, you were served with that order. You were served with that order. Okay? You were served with that order, and it's also on the state system. Okay? So,
Is it not?
ma'am, I won't ask you again.
Can I just show you something, please?
Boss,
Sir, can I just show you something?
boss, you probably should have did like you did last time when you came to get property. Remember when you came to get property? I was here.
Can I put my property in my property?
No, you're going to
No,
jail,
I understand.
and you're gonna get charged with aggravated stalking on the family violence.
Are you kidding me? Because
No.
it's been over with.
No, it ain't over with. It's still active.
I have a knife in my pocket because I carry
That's
now.
fine.
20 from me, go ahead.
Wow.
Do you have any medical conditions at all?
Put it in the front. In the front.
You have any medical conditions at all,
Can I
boss?
get my?
Diabetes, epilepsy, high blood pressure, anything like that?
My
man?
family name?
Yeah, we'll put it on.
Stolen on a 2010 Nissan Altima black color. Valid.
You're taking me to jail. This is amazing. This is amazing.
Boss, the best thing that I can tell you, when you go to court, you may want to hire an attorney so that we can get it straightened out.
This is amazing. Can I make a phone call?
That tag is stolen on a
You go on the other side, sir.
Where is he? I would. Wow. This is amazing. This is amazing. Even though the TPO was over with, son,
Have a seat.
it was 12 months. I'm not fighting. I'm just asking. It was 12 months. Sir, I'm not. Sir, slide in. I can't even talk to you. You won't talk to her.
Man.
Please, my God.
I read the paperwork.
But it says 12 months.
Slide in.
Sir, it said 12 months. Wow. It says 12. Please.
Watch your foot. Watch your foot.
Listen. Can I just talk to you? Come on.
You gonna talk?
Can I talk to you?
Frank, Robert, Edward, Michael, Ed, Nora. First name is Lincoln Edward, Ida, Lincoln, Adam, 1987-0906.
You want me to get her 39? I'll get it. Okay. Sure, because I was going to say, just go to the jail because it's extra out here.
I'm not going.
Hey, Reeves, take a picture of that
No one.
TPO from me.
ages 5, 18, 16, and 18, 26.
Hold on.
725 already.
Can I at least talk to the girlfriend? She's right here.
25 Central.
You just let her talk to me through the window. Sir, please. Damn, man. He said 12 months.
Show me transport one black male. 019. Starting model is 137. 218.
Like I said, said 12 months.
706 radio. Code 5 for 726. 5120. 5120.
All right, that was Exhibit 8. Do we need to replay it again at this point? Seeing no hands? Okay, if you need it later, let us know. And then I think it's Exhibit 9, whatever the exhibit was, it was admitted through Sergeant Broussard. It would be his body cam. And same request to the jurors, any issue if we fast forward it to Sergeant's arrival at the scene. There's no objection to that, so let's do that. Thank you.
I was under the impression because you don't have contact. Yeah, I got some here going as well. I saw you last time I was out here.
Same note. I had these copies made to the same.
Hey, come on now. Over there. Over there.
Here.
Over there, bro.
Yes, sir. The road's like I'm having a birthday party for his son. My son, Henry, is here, and he comes jumps out the ice pool saying it's his. I got to get out of his house, and I have these documents. I don't have to go anywhere. His back name, my nail brown. That's his side. Coming in cursing us, calling us bitches, telling us to get the fuck out. I got a backyard full of shit.
Court order still.
It's my brother's birthday party. And
2021.
I remember because he came over here last time to get property.
And I remember, I would do what I remember. He's taunting my mom. He just heard he said shit from me on nose, and I smashed. And this is my son's birthday. Got the gaming truck outside for my boy, a water slide in the backyard full of kids.
785 for 1.
727, 10-4.
He doesn't even have a license. I don't know how he got over here. Right.
This.
I was going to take him away.
I remember because he had to come here.
727. Confirm you at Marketplace Boulevard in North
Stuart Bryant. What's his birthday?
October 76.
October 31, 76. Let me check and see if it's on GCIC. If it is, then we'll go from there. State it with them.
24 radio. 24 radio. If I think about
724, 10-4. $725. Broussard. 3051 Park Street, apartment A, Adam, signal 23. Your complainant is a 7-year-old, advising that his grandmother is hitting him.
Judge, do you want to inquire of the jury if they want me to continue playing through this computer check? Happy to, but.
So we should inquire. This wasn't played when the sergeant was testifying. It's in evidence. The whole video is in evidence because I think you asked the defense if there was any objection to fast forward to completing the check and then re-engaging with the people who were up at the top of the driveway. It's your video. You want it to keep playing, or do you want to get back to when the sergeant was interacting with people?
Interacting. Sergeant. Just to hear what he said, yeah.
Okay, press play, please.
3051 Park Street, 809 the apartment. Apartment A, Adam.
King truck.
Okay.
Thank you. Thank you. Thank you.
Hold on. Hold on. Put your hands on your back. Are you serious? Yes. Why is that? You know you were served with that order. You were served with that order. Okay? You were served with that order, and it's also on the state system. Okay? So
Is it not?
ma'am, I want to ask you again,
Can I just show you something, please?
boss,
Sir, can I just show you something?
boss, you probably should have did like you did last time when you came to get property. Remember when you came to get property? I was here.
Can I put my property in my girlfriend's car, please?
No, you're going to jail.
No, I understand.
And you're gonna get charged with aggravated stalking on the family violence.
Are you kidding me? Because
No.
it's been over with?
No, it ain't over with. It's still active.
I have a knife in my pocket, because I just carried,
That's fine.
I wasn't
27, go ahead.
Wow.
Do you have any medical conditions at all?
Put it in the front one, in the front one, please. It's going where it's going, but pretty much.
Do you have any medical conditions at all,
Can I
boss?
get my,
You take diabetes, epilepsy, high blood pressure, anything like that,
put
man?
my phone in there?
27,
put it on.
stolen on a
This is
2010.
amazing.
Just we gotta let the jail know about this night when we get in
It's
there.
okay.
Because they're
You're
probably,
taking me to jail. This is amazing.
Charles Paul
this is
5566 CTP
boss, the best thing that I can tell you, when you go to court, you may want to hire an attorney so that way you get this straightened out.
This is amazing. Can I make a phone call?
When you get to jail, yes.
On a 2020.
All right. Hey, put this on my butt.
I wouldn't. Wow. This is amazing.
Two females.
This is amazing.
Go ahead.
All right, have a seat.
Even though the TPO was over with, sir,
It's still not over. Have a seat.
it was 12 months. I'm not fighting you. I'm just
I got you. Have a seat.
It was 12 months.
Subcommon spelling 1987 0713.
Have a seat, boss. Come on, you'll talk to you at the jail.
But it says 12 months. Sir, it said
Have a seat.
12 months.
I got you. Thank
Wow.
you. Thank you.
It says 12.
Watch foot.
Please,
Watch
please.
foot.
27,
Watch
she has
foot.
no warrant for the valid charge. Go ahead.
Can I talk to you?
You will.
Last name is Frank Robert Edward Michael Adam Nora. First name is Lincoln Edward Ida Lincoln Adam 1987-0906.
You want me to get her 39?
I'll get it.
Okay. Sure, because I was gonna say just go to the jail because it's extra out here.
You want to go on the thing? Hey, how
Hey,
are you?
good
No
man.
warrant. Copy 5119-5119.
Information still the same. That when we did the police report last time. Phone number 2. So.
When I went to court, they dismissed my divorce because they said the police officer wrote the case down. But I have it where they put on the paperwork where he was served with the document.
It's still in the system that he was served with the paperwork with the temporary protector order.
But I'm talking about for the divorce. Can I show that to you, or should
Divorce is
I
fine, take a look at it, but you probably got to do a refile.
And that's what they told me. Go ahead and refile. So is there a way because of this incident that I can get this extended for a little while longer?
That's correct. What all? 706 radio. Code 5 for 726.
I turn around and say, go and try to gather the kids for y'all. Hey, mom.
Copy 5120. Ten 723, you can 16.
I'm gonna get my phone and I'm gonna take pictures of that because I need it. Here you go.
Hello.
That's the case number for today.
Okay, and I'm going to go get the other document so that you can take a look.
So I'll be right back. Okay, I'm gonna get my phone.
This is the one that gave the girls the whole talk about like the who Officer Broussard? Right here.
Sure.
I know him. Talk about gangs and everything. Right.
Let me
That's a good tip.
let me pull up so I can.
They come by the house,
Okay.
talk to the kids.
Yeah, let me pull up and I'm gonna get my phone so I can take a
I've
picture.
been
Okay.
at this point for almost 30 years.
Oh, yeah? Well, he knows. He was here last time when we were here when he came to get property. So he knows. I was here. You're welcome. I'm coming right back. I'm just getting my phone.
Is there more than just jingling for the rest of it?
There's some jingling and some back and forth. I mean, they want to see there's 5 more minutes.
No, that's fine. I just wasn't sure if all that was left was walking back.
No, no, he's gonna move up. It's not just jingling.
Okay.
Gave you an idea? Huh? Gave you an idea? I could tell. As soon as you got your phone, like, it gave this man an idea. Did you go look in the inside? No. I was gonna take a look in the inside while we're waiting. No, in here. Give you an idea.
All right.
I'm gonna wait for them to come out. Yep.
All right, I was only saying that we are.
Yeah, just take a look. Do what you gotta do.
To the radio, you can show you in the signal 7.
722, I'm clear.
can't locate the document. I think my mind is.
Where's the TPO again? I'm gonna take pictures of it.
Already transmitting away code 3. 2521.
To the radio, you can show your signal A code 3.
722. 725. Copy signal 41 at Kim Creek Parkway and Potomac Drive. 78 is on a silver Kia Rio and a red Toyota Scion. 25 and clear at Camp Creek and West Potomac.
Is there more related to this case? I mean, you've watched it before. If it's just the radio talking about other incidents and he's,
That's my recollection. Is that?
I don't think anything else is related to this case, Judge.
okay, let's stop. All right, anyone need that played a second time at this point? No. All right, ladies and gentlemen, I ask you to return to the jury room to continue your discussions. If you need anything else, you know what to do. Fill out one of the cards or a piece of paper from your pad. Mr. Whitenauer, anything more from the state?
Nothing from the state.
Ms. Wood?
No, Your Honor.
All right, then we'll pause again. I'll mute the microphone, put on the deliberations thing. Ms. Rivers, I'm going to give you this set of cards when we're off the record to make as court's exhibit 1. It's all 47 of the submitted juror questions. So not the 2 that just happened. Those are deliberation questions. These are the questions that followed witness testimony. It's everything, whether I ask them or not. This will be made part of the record. Okay, thanks, everyone. Mr. Wooten, thank you for coming back. I had forgotten because this other stuff was going on. Now is a good time. Yeah, I'll let you back. Just come on up. You just do 2 things. Okay, Ms. Rivers, you ready? We are back on the record in State versus Bryant. Deputy Gordon tells me that the jurors have reached a verdict. So I plan on bringing them out and receiving that verdict. Anything, Mr. Whitenauer, before the jurors come on out?
No, Judge.
Okay, Ms. Wood.
No, Your Honor.
All right, Ms. Feely, you've been standing for a while. Was there something you needed to get on the record?
Too much sitting.
Too much sitting. I know how that works. Let's bring the jury in, please. No, they stay out till we sort out what's happening here. Thank you. Do we have letters for them?
Yes.
Great, thank you.
All right, adjourned. Our jurors are present.
They are, so I make sure we had all but two. Our four-person, are you the four-person? Can you stand? Great, did you all reach a verdict?
We did.
And was the verdict unanimous?
Yes.
Have you recorded that verdict in writing on a verdict form?
We have.
Could you give it to Deputy Gordon, please? All right, thank you. Back. So I'm going to ask you as the four-person to publish the verdict, which means read what the jury's verdict is for each of the two counts.
For count one, aggravated stalking, we find the defendant not guilty. For count two, for simple battery, we find the defendant not guilty.
All right, if you would please give that to Deputy Gordon, and he will share it with Mr. Whitenauer and then with Ms. Wood. Mr. Whitenauer, any objection to the form of the verdict?
No, Judge.
Ms. Wood?
No, Judge.
Okay, any reason I cannot release this jury, Mr. Whitenauer?
No, Judge.
Ms. Wood?
No, Your Honor.
All right, ladies and gentlemen, you're not quite released yet. You're going to go back to the jury room for a second. I got to give you all letters if you need them for employers or significant others. I want to thank you back there on behalf of all the parties. You gave us 2.5 days of your life, however long it was, to work through this important issue, important for everyone who was involved. And you gave it your undivided attention. And that's what we need jurors for. So thank you on behalf of the lawyers, on behalf of Fulton County, and Mr. Bryant. I'll be back there in just a second. We'll reunite you with your electronics, and then you will be on your way. Thank you so much.
All right, adjourned. You get, two alternate votes.
Yeah, now you can get the alternates.